as a background, I was listening to the remarks with regard to the pandemic and how it's not over, and I really feel that is the case, because as I speak to you now, I'm actually in isolation in my house in Geneva. And that despite having been double vaccinated. So it's quite true what has been said with regard to the fact that the pandemic is not over. I'll just provide a few introductory remarks about the IHR. As many of you know, the IHR has really become the legal framework, I would say, for the international response to the pandemic. When the IHR came into force in 2005, and I had the opportunity to participate in the revision of the IHR, which is of course an older instrument. We knew that this type of event was going to would fall within the framework of the regulations. And so I'll just say a few words about the legal nature of the IHR. So as many of you may know, under the WHO Constitution, the Health Assembly has legislative making powers. There are mainly two types of instruments that the Health Assembly can adopt. On the one hand, conventions, which is what we have with the Framework Convention on Tobacco Control, and on the other hand, regulations. Now, the IHR fall in the second category. The main difference between them is the fact that conventions must be ratified, whereas the regulations, and there are two different regulations. One, the ICD, the International Classification of Diseases, which many don't realize are regulations under the WHO Constitution, and the IHR, the International Health Regulations, previously just 1969 known as the International Sanitary Regulations. So these regulations come into effect and are legally binding on the member states of WHO automatically, unless they are either rejected or a reservation is filed with regard to one or several of those provisions. So it really is quite a unique instrument of international law in that sense, that it is an opt-out and not an opt-in instrument. Perhaps I'm just going to say a little bit as well about, and I'm happy to take questions. Obviously, this is a very broad area. The IHR covers very multiple sectors. It has a very broad scope as well. But I'll just say a few words perhaps about the committees that the IHR houses, because they are quite relevant to this pandemic. So under the IHR, an event, a public health event that has pandemic potential, for example, is notifiable by a member state. And in order to guide member states on which events may or may not be notifiable to the World Health Organization, there is a decision instrument, which is located in Annex 2 of the IHR. And that decision instrument has 4 different criteria with regard to the type of event that might be notifiable. On the one hand, the event can be unusual or unexpected, for example, for that particular season. It has to have serious public health impact. It may have an effect on international traffic and trade, and there may be a risk associated with that particular event of international spread. So once 2 of those criteria are met, the member state in question who has picked these up must notify the World Health Organization. And that is the beginning of a dialogue and a joint risk assessment between WHO and that particular state or group of states. If it's found that that this is an event that needs to be given further consideration, our Director General has the executive authority to convene an emergency committee. And that is one of the two committees under these regulations. One are emergency committees, and the others are review committees. And I'll come to the second committee later on, which is relevant to the area of legal preparedness and that we're discussing today. So in the instance, to give an example, in January of 2020, the Director General convened the emergency committee for, at the time, SARS COVID, or what was happening at the time, the event that was unraveling at the time in one member state or two at the time, which in particular China. And so that committee came together on the 23rd of January, and they had the task, on the one hand, of determining whether this event reached the threshold of a public health emergency of international concern. This is a term of art, which is defined in the IHR. And the two elements of this public health emergency of international concern is that there's a risk of international spread and that an international coordinated response is required to address that threat. On the occasion of that first meeting on the 23rd, it was found that there was not enough information to recommend to the Director General that he should declare a public health emergency of international concern. So he didn't. But less than 1 week later, the committee was reconvened and their substantial spread had occurred, more information had been received, and on the 30th of January, the World Health Organization and its Director General declared a public health emergency of international concern. And along with every public health emergency that is declared, the DG issues what we call IHR temporary recommendations, mainly to states, to give them a guide on the measures that they can take in order to prevent the further spread of the disease. And so this committee has met on 9 occasions now, and the latest occasion was just this 22nd of October. The other type of committee that the IHR houses is the IHR Review Committee. Typically, the IHR Review Committee is brought together to evaluate how the IHR has functioned during a particular emergency or event. And this committee has met on several occasions. It met following the H1N1 pandemic. It met following the Ebola crisis in 2014. And most recently, it has met, even though the pandemic is not over, it has met to review the functioning of the IHR during the pandemic. And it met from mid last year mid 2020, and it provided its report to the World Health Assembly at its 74th session in May of this year. Interestingly, one of the recommendations one of the series of recommendations, and perhaps Geneviève or Ben will go into more detail on this, one of the series of recommendations were with regard to legal preparedness, specifically. The IHR does not mention legal preparedness explicitly, but if you do look at some of its provisions, there is an expectation that countries will have the necessary legal framework to implement their obligations and to perform their duties under the regulations, or to exercise their rights, if you like. But for once, and this is a first for a review committee, there was a specific section on how countries should strengthen their legal preparedness through the periodic review of legislation, especially in the health emergency context, through as well through partners, and we are very happy to take this work forward. The recommendations from this review committee, however, are still under consideration by a working group on a member state working group, on strengthening WHO preparedness and response in public health emergencies. And this group was put together to review recommendations from several panels in relation to the pandemic and the response of the world community. That working group has met on 4 occasions now, and the idea was for the working group to present its findings to a special session of the World Health Assembly, which will take place at the end of this month. That session will bring together all member states because it is a World Health Assembly session, and it will look at the recommendations of different panels. It will also look at the discussions or the opportunities and challenges of adopting another instrument of international law, commonly referred to as a pandemic treaty. And the idea of this treaty would be to fill in the gaps that the IHR does not cover, such as sample sharing and other areas with regard, for example, to on-site investigations of particular public health events, which are not explicitly captured in the IHR. As part of that discussion on adopting a new treaty, there is also a group of member states that feel that the IHR are an instrument that has been effective, that it covers many of the areas that are needed to address these types of public health emergencies, and that what we have observed, the main challenge is its implementation and not necessarily the text itself. However, there's another group of member states who feels that the deficiencies that have been revealed in this emergency require the IHR to be amended. So we find ourselves in a situation where we have proposals to adopt a new instrument, and we also have proposals to amend the existing regulations. How this will all play out is not quite certain, and that is part of the mandate of this special session to determine how the IHR can be better adapted or suited for the future, and also whether or not the world needs a new internationally legally binding instrument to deal with future pandemics and health crises. So perhaps I'll just stop there. I will be on the line for a while yet, even though it's 2:30 in the morning here, but I will stay on for any questions. And once again, I just wanted to thank the participants and also the organizer for giving me this opportunity to address you. Thank you. Over.
Thank you very much for your presentation, Fernando, and especially for doing it at 2:30 in the morning while you're in isolation. So thanks for reminding us all of the importance of the IHR. I think we're all very interested to see where the member states get to for the proposals to amend the IHR and or to adopt a new pandemic treaty. So next, I'd like to introduce Dr. Tamano Matsui from Wipro's Health Emergencies Program.
Thank you, Chair. Good morning, good afternoon, good evening, everybody. I'd like to double check whether my slide is appropriately shared. Okay, I move on. It's a great pleasure to present at this meeting. Thank you so much. AFSET is the strategic action framework in the region for implementing the IHR capacities. It's currently in its third iteration since the first one was implemented in 2006. Each year, an AFSET technical advisory group meeting is held to monitor implementation of AFSET and IHR and provide technical advice and recommendation on priority actions to invite member state technical advisory group members and partners. Here are several important principles of the AFSET are outlined. System approach is used to build systems as a means to emphasize long-term goals and sustainability rather than using the short-term goal attainment approach. Flexible and tailored to country context. Respond and improve to have continuous improvement. I will tell two-tier approach in the next slide. First tier of the two-tier approach is the emergency planning, and it has two parts: response plan and ongoing planning and coordination process. Second tier is the system readiness. It means ensuring the availability of all structures and resources. It allows response plan to be implemented immediately and effectively. Action specific to the event is the main point of the response second tier. However, this should be used to modify planning while responding. This is not only for the specific event, but also helpful for planning of other type of events. In summary, upset two-tier approach is preparing while responding. At the upset tag meeting in July this year, the experience of the member states and lessons identified from 18 months of responding to COVID-19 were reviewed, along with conclusion and recommendation from reports presented at the 74th World Health Assembly. The TAG 2021 meeting concluded by providing recommendation grouped under two outputs. Output one, focusing on the short to midterm recommendation and paid attention to two scenarios. One scenario was that the virus is entrenched globally, and as such, consideration should be given by member states to treating COVID-19 as endemic. The second scenario was the potential for a pandemic within a pandemic, where a more virulent variant emerges that evades vaccines and has severe impact. Output two recommendations focused on long-term strengthening of health systems to make them more resilient, and member states asked WHO to study and determine the elements for the preparedness framework for the next pandemic. WHO is developing guidance for member states on planning for endemic COVID-19. The conceptual framework shown has two reference points at the top, and those can be used to calibrate the response. The red line, which we want to avoid, is the point at which the capacity of the health system is exceeded. We also want to protect the vulnerables. While vaccines are important and key to the response, they can't suppress transmission on their own. They should be combined with public health social measures that we know work. Public health social measures may be individual-based, for example, mask use, risk-based, or population-based, also known as the blanket measures. Blanket measures may be applied in areas where cases are rapidly increasing and include school closure. Schools are very important, and their closure impact negatively on children's health and well-being. Other actions shown as key areas in the framework are early detection and targeted response. It's important to detect infections early in order to suppress transmission. Improving capacity of the health system as a measures to prevent the red line being exceeded. And international border measures that takes a risk-based approach to manage the risk of exportation, importation, and onwards transmission. These five key areas are supported by three important pillars: surveillance, including genome sequencing surveillance system and monitoring all-cause mortality information, communication, and contact tracing. Taken together, these key areas and pillars advance and strengthen capacity for preparedness and response to large-scale community transmission, and require a command system to coordinate a multi-sectorial whole-of-society approach. Long-term investment in health system, applying upset principles to realize the vision for the future towards the healthiest and safest region, and using universal health coverage as leverage can enable more resilient health systems and societies in the future. Thank you for your attention.
Thank you very much, Dr. Matsui, for that excellent presentation. To conclude this opening session, I'm going to make some general comments on and touch on some of the themes that we can expect to see fleshed out over these 2 days. First, to restate what has already been said a number of times, that law plays a crucial role in responding to COVID-19 and to health emergencies more generally, and then beyond health emergencies in public health more broadly. Law is critical in both preventing and controlling the spread of COVID-19 and in ameliorating its many health, social, and economic impacts, from the collection and use of health information to public health and social measures such as requirements to wear masks and other personal protective equipment, to contact tracing, to quarantine and isolation, to stay-at-home orders, or to what have become known as lockdowns, to vaccine development, safety, quality and efficacy, and to vaccine mandates where these are adopted, to employment protection and social protection, to enabling the mobilisation of additional healthcare capacity, to ensuring quality and safety in healthcare facilities, and to protecting and promoting the health and well-being of healthcare workers, to ensuring infection prevention and control in facilities with vulnerable populations, such as residential care and corrections facilities. This isn't intended to be anywhere near a comprehensive list, but just to provide a few examples. Across these many relevant areas, difficult policy choices need to be made. When to use law versus other approaches, education, community engagement, public funding of support programs, and when to use law together with these other approaches, how to promote both individual rights and health and population health, and how to balance them when they come into tension, when to introduce legal measures and for how long to keep them in place, and what kind of mechanisms might be needed to supervise, oversee, or constrain the exercise by governments of what are sometimes extraordinary powers, how to make the most of what modern digital technologies have to offer while ensuring appropriate protections for privacy, how best to encourage and support compliance with legal requirements in circumstances where compliance can be very difficult for people, with restrictions on freedoms usually taken for granted, impacts on our most important relationships, on the ability to earn livelihoods, and when and how to use law enforcement approaches, and when law enforcement activities are necessary, who or which agency is best placed to undertake them, how best to engage with the private sector, drawing on the many contributions it can and must make to public health responses, whether as an employer, a provider of essential goods and services, a healthcare provider, while regulating it as required. And of course, these difficult choices often need to be made in situations where evidence and understanding are constantly evolving. Conditions are rapidly changing and interventions may need to be maintained or lifted and then reintroduced over considerable periods of time. And then across all aspects of our approaches, how we can make sure that equity is and remains at the centre of what we do, understanding the differential impacts of COVID-19 and laws designed to address COVID-19 on different groups and individuals, depending on their circumstances, paying particular attention to the needs of vulnerable and marginalised communities. And then thinking about equity not only within countries, but globally too, how governments can both protect and promote the health and well-being of those within their own jurisdictions and contribute to the health and well-being of those in other countries. As we make our way through the forum, we want to be considering not only the COVID-19 experience, what has happened so far, and the challenges that countries are currently facing and are likely to face in the months ahead, but how we can build legal preparedness for future health emergencies beyond COVID-19, and what we can learn about using law to protect and promote health beyond health emergencies, recognising the enormous diversity across our region in legal systems and cultures, resources, capacities, and experience in responding to health emergencies. So we're all looking forward to what is sure to be a rich discussion, the insights that emerge from our collective experience, and to thinking about how we can work together beyond this forum. So thanks all for joining us for this opening session. We'll move to the next session soon, but I think now is time for Wipro's traditional group photo. So I think I'm handing over to Cynthia for the group photo. Thanks very much.
Okay, everyone, may we request you to please open your camera. We'll be taking a group photo. Okay, hold your smile after 1. In 3, 2, 1. Hold for a while. Hold. Okay, one more. Hold on. Hold on. Hold. Okay, thank you, everyone. Thank you.
All right, thanks very much, Cynthia, and everyone. So we're going to head straight into the next session. For those who are just joining us now, a reminder that the event is being live streamed on the Melbourne Law School's YouTube channel. It's being recorded and will be posted on the university's website soon after it concludes. So I would like to reintroduce Dr. Genevieve House, Coordinator of Health Law and Ethics Unit at WHO Wipro, for session 2, which is on the role of public health and health emergency laws during COVID-19 and opportunities for strengthening. Thanks, Genevieve.
Thanks so much, Jonathan. Good morning, good afternoon, and good evening to everybody, and a warm welcome to session 2, the role of public health and health emergency laws during COVID-19 and opportunities for strengthening. When we think about law and COVID-19, depending on our own experience and the country we're in for the past 18 months, very different things may spring to mind. Our region is so diverse, and no country began with the same law or used their laws in the same way. In my brief opening comments, I'd like to reflect on some of the many ways that laws were used in the COVID-19 response, and drawing on and perhaps adding to some of the comments that Jonathan made, because it's a very neat pathway from those comments into this session. Across our region and globally, there was great variation, but I will touch on some broad themes. The basic health function of surveillance, so the ability to detect, test, isolate, and treat every case, and to trace and quarantine contacts based on public health advice. Most countries have laws which support this kind of activity. Restricting movement. COVID-19 is highly infectious, and some variants are even more infectious. To mitigate or prevent transmission, many laws enable imposition of rules on behaviour that restrict the free movement of people and their use of public spaces. And some of these can impose restrictions on people's human rights. Most people use laws to impose measures to manage the public health risks at points of entry, restricting entry, or seeking information from arrivals requiring testing, the imposition of quarantine. Some countries use laws to support the collection, reporting, and use of health information and data of vital function during an epidemic. Some laws also impose requirements for protection and privacy of information based on human rights principles. Many countries observed an increased need for medical equipment and supplies, vaccines and the like. Laws were used to help address this. For example, prescription extensions that encourage people to stay home. The alteration of statutory requirements about government procurement to enable swift emergency procurement of necessary drugs, medical supplies, vaccines, and so on. Emergency laws and orders may also restrict broad availability of some drugs to ensure quantities needed to treat COVID-19. Some laws ensure the safety, quality, and efficacy of drugs and medical products. Legislation may enable telehealth and other uses of technology, but these will be covered in session 3. Emergency temporary or emergency registration of health workers was enabled by some countries through law. Others provided for limited expansion of the scope of practice of some health workers to enable task sharing between cohorts, such as medical practitioners or nurses, or task shifting, for example, from nurses to community health workers to make the best possible use of the available workforce across a country. For some countries, laws were used to involve the private sector in emergency response efforts, as Jonathan said, a crucial way to expand capacity. For example, to increase available system capacity, including available hospital and health facilities and services such as laboratories. This was done quite differently across different countries. A few examples include by contracting, by emergency order, or the use of tax incentives. Laws were used to protect human rights and to protect those disproportionately affected by the health measures that were imposed. Many countries have ratified the International Human Rights Conventions and variations, mixes of these, and have a legal obligation to give them effect when they've been ratified. Many countries also have human rights protections in their constitutions and other laws that would have and did have application in all COVID-19 responses. Ensuring the availability of accurate and reliable information on the emergency to the public was a challenge for many. Some countries conferred responsibility via statute or by administrative means on a senior official to be the one source of formal information delivery to try to communicate more clearly with the public. In an age of swift transmission of information via social media and other informal means, it can become a complex exercise to communicate clearly and effectively. Some countries designated the spread of false information as an offence. Laws were used to attempt to ease the financial burden of the COVID-19 crisis in the form of mandating payments for workers who couldn't attend work, the provision of rent relief, or other kinds of benefits. Laws were also used to try to safeguard the rule of law during COVID-19. For example, in some countries, laws were altered to allow parliaments to sit remotely, or courts also to sit remotely, or to undertake the different use of rules to allow them to continue under the altered circumstances. These are just a few examples of how laws were used during COVID-19. We're learning all the time, and as we've heard in the introductory remarks, that is in fact the purposes of our forum. In our panel, we're going to hear from 6 experts who will provide their wisdom, their unique perspective in a 10-minute presentation each, and then contribute in the open discussion. And so I'd now like to introduce our panelists for this session. Mr. Mapo Fazu, the Disaster Law and Advocacy Manager, Pacific International Federation of Red Cross and Red Crescent Societies. Mr. Belkama, Department of Pacific Affairs, Australian National University. Mr. Bob Williams, Secretary of Health, the Cook Islands. Sorry, we've just lost my thing again. Mr. Bob Williams, yes, Secretary of Health, Cook Islands. Ms. Mandy Charlton, Director, Border Health, Department of Health, Australia. Dr. Pozikai Samuel Tapo, the Director of Corporate Services, Policy and Planning, Ministry of Health, Vanuatu. And Dr. Lu Yang, Legislation Department, National Health Commission, China. And then I'd just like to hand over to Alyssa, who's going to explain the use of the Padlet, and then we'll hand over to Mr. Fasu.
Thanks, Genevieve. And thank you everyone for joining us at the forum today. Really great to have you. My name is Alyssa Liu. I'm a consultant with the Health Law and Ethics team. So as we proceed with the forum over the next 2 days, we invite you to share your thoughts and reflections with us, to add on to the discussion with our panelists through this platform we're using called Padlet. I'm now about to share a link on the Zoom chat. Please have a look, please click on this link, and the password is health law in small letters. So just type that in and go to that link. I'm going to also just share my screen here for our viewers who might be accessing this forum on the live stream. Just 1 second. So for our viewers on live stream, this is the link that you should be typing in, and the password is, again, health law. I'll just give it a quick second and I'll show you how to use the platform. And if one of our colleagues is able to just put this link and password into the YouTube live stream chat as well, that would be very helpful. Thank you. So, okay, so very quickly, once you're in the Padlet, this is what it will look like. This is for day 1, session 2. These questions are the same questions that we posed to our panelists as they prepared for their remarks for this session. To add a comment, for example, let's say to the second question, you click on the plus button, and in the subject, please put in your name. So for example, my name is Alyssa Liu, and then comma Wipro. So put in your name and affiliation or country here, and then over here, you can write your comments. And once you're done, you can just publish and it will show up right here. If you do not have any responses to these questions, or you would like to share reflections, you can also add in other comments or questions that you have here under other comments. And then towards the end of the session, Genevieve will pass back over to me and I will do a quick recap of everything that is received. So I hope this is helpful. I'm still available on chat if you have any questions about accessing Padlet, or if you have any questions about how to use it. Thank you. Over back to you, Genevieve.
Thanks so much, Alyssa, and a big thank you for all your innovation and assistance in introducing us to the use of these new tools. I'd like to hand over now to Mr. Fazu, who will be our first panelist to present. Thank you. All right, I'm not quite sure where Mr. Fazu is, but perhaps what we might do is go to Dr. Bell Karma. Dr. Karma, are you with us? They're from the Department of Pacific Affairs, Australian National University.
Thank you, Genevieve. Hello, everyone. And thank you for the opportunity to be part of this very important forum at a very significant time, I think, of human history, in that, you know, the whole world is confronted with something that it is perhaps hasn't seen in a long time, and it has shocked systems, institutions, and people, and especially for vulnerable societies. I think the COVID pandemic has really a huge set of impact on them, and one of the areas that is quite critical, of course, is the subject of our talk today, which is the legal framework. How do we govern such, and when we are governing it, what kind of considerations do we take into account? And my observations will be based on some of the countries in the Pacific Islands that I have observed. And obviously, I haven't observed all the 14 countries in the region. So I am definitely open to also learning from others in these discussions that will follow from this conversation. And of course, from other countries in the region that the WHO Western Pacific covers. So my observations, especially on, and I will talk, trying to cover the 4 questions that are being guided, which I think are really good in guiding such a talk. So I will try to cover them as I speak broadly on it, and then hopefully discuss more when we come to the question time. So my observations based on Papua New Guinea, Fiji, and Solomon Islands, especially concerning the first question, where to what extent have legal frameworks for public health and health emergencies supported an effective COVID-19 response, and what are the challenges and limitations? Observations from these countries, and obviously I am choosing those countries, Papua New Guinea, Fiji, and Solomon Islands, because they are comparatively the three larger states in the Pacific Islands, and some of their messes were quite much more extensive compared to the other smaller states. So looking at those three states, they were initially using the powers within the Constitution regarding the emergency laws, and then eventually bringing other laws and regulations to monitor and continue to administer COVID-19 measures. But the initial use of the emergency powers gave rise to a lot of concern, obviously, because the emergency powers in these countries have give sweeping access to the controllers of the powers, and it raises concerns about to what extent, or where is the balance between that and the human rights of the people. And they were at least, the sense of effectiveness, the fact that the situation was serious and it demands a serious approach, the use of emergency powers give that picture of how serious COVID-19 was, or when it first entered these countries. But I think there are some sort of insights that we can gauge from how, say, countries like PNG and Solomon Islands kind of approach those powers. And in terms of Papua New Guinea, it did use the emergency powers, but then decided to use the Pandemic Act to manage the ongoing management and the administration and to coordinate COVID. Whereas in Solomon Islands, they decided to continually use the emergency powers and place a larger sort of reliance on that. And as you can see, or you may have heard, last year there was about 8 months of lockdown, nationwide lockdown in Solomon Islands, and this year there was about 4 months of lockdown as well, again based on constitutional powers. That raises significant concerns about certain limitations on human rights for that extent. PNG decided not to, because one of the main reasons between, say, Solomon Islands and PNG in not using constitutional powers, but using Pandemic Act in the case of Papua New Guinea, is that when those countries with emergency laws, there was a lot of scrutiny that is expected, say, in Papua New Guinea, where the person managing the emergency powers has to report directly to Parliament and seeks Parliament exclusive approval to continue that emergency powers, whereas that is not required under Pandemic Act. So bringing in Pandemic Act was a way to get around that very very tight sort of scrutiny, and obviously, that also means that pandemic sort of response doesn't need to be subject to too much politics. Obviously, Pandemic Act allows for a much more swifter response, but it does raise the question about accountability. Emergency powers that implicates on rights, that's only accountable to the executive government, to the cabinet, and not to parliament, raises questions in Papua New Guinea. Whereas in Solomon Islands, for instance, there is a lesser kind of accountability framework around the emergency powers in terms of there is no firm expectations provided for you to be reported to Parliament. There is while the emergency powers provide for a broader scope of powers, doesn't on the same level provide for a great accountability. So obviously the government prefers that to be a better option than having a separate legislation guiding the powers used to effect COVID-19 response. Now, there are three sort of challenges which I'd like to quickly get into. Firstly, I think the use of emergency health laws in the Pacific countries generally raises the question about human rights, and many, in fact, all of the Pacific states have certain Bill of Rights within their constitution. And so that is a ongoing concern. And especially the use of police and military in trying to impose the emergency laws. And that brings to the second challenge is how prepared are these enforcement bodies? I mean, when it comes to enforcement that is led by police and defense, they are perceived as, punitive. They are the agents of a legitimate state violence. Now, how do you change that job description in a pandemic setting where there's a lot of social distress, there's a lot of need for empathy, and how do you change the role of police and defense force who are perceived as agents of state violence, or agents who are more keen to more, punishment-oriented kind of work, to now have that new sort of role. And I think that's a struggle that speaks to the level of training that maybe the police and the defense force may be having as well. I mean, how much of their training take into account situations where they will be able to lead in, say, pandemic settings, where there is a lot of social distress and a need for more, much more empathy as well as enforcement. The other thing that the challenge of the enforcement part is that many of the law enforcement agencies in the Pacific do not have proper counseling systems set up within the enforcement. So they don't have a service for debriefing and their own mental health. Those things needs to be really taken a closer look at, because we are sending them out without having that. Pardon?
Just a reminder, retime.
Sorry, is my time up?
No, I just wanted to know you're getting quite close. I'm sorry. I just wanted to give you
okay.
Yeah.
Sorry. I should probably just run to the there's another point that I would like to raise for our consideration, is about the consistency of policy between government. Yesterday, for instance, Papua New Guinea, one of the largest mining firms, there are about over 1,000 mining workers that have been reported to actually resign because they don't want to have they don't want to have vaccination. While the government doesn't have a strong position or doesn't have a firm position on whether or not vaccination is a mandatory thing, it allows private entities to actually mandate that. I think there is a gap there in terms of legal and policy consistency, leaving it for private entities to decide on methods that have larger social implications. I think there needs to be thinking around that as well, in that, does government emergency powers reach out and also decide on policy matters that concern private entities and what they should and shouldn't be doing. And that is obviously a concern for Papua New Guinea. In the last couple of weeks, there's a lot of protests around that as well. Now, one of the major issue that I think government will be facing going forward in terms of looking into the future is that the social media, many of the governments in the countries that I've looked at have raised serious concerns about the use of social media in trying to undermine government messaging. And they're thinking of how do we kind of limit that. But again, it does raise the question about, does the need to have stronger public health emergency laws and ensure that there is success in that regard include suppression of certain rights that are perhaps fundamental to having a balanced view about things. And media, for instance, is something that some of the governments are also considering, and whether that is a much more reasonable approach to dealing with something like pandemic. The other things that perhaps can speak to WHO and many other external entities is the influence from the influence of external bodies on internal policy making, and there are concerns being raised about, is it constitutional to allow external entities having a greater say in how local policies and laws are being designed. And I think these are some of the things that speak to the minds of Pacific states, which I've come across. Now, I will finish off with, there are some major court cases that are currently on foot in Fiji and Papua New Guinea, or talks about bringing cases where things like no jab, no job policy, or the PNG courts, for instance, is now imposing no jab, no entry to the court, meaning that it's denying lawyers and litigants to enter court if they don't have jabs.
Dr. Kama, please wrap up as soon as you can. Thank you.
Sure. So I think, for instance, that PNG case raises questions which speak to the fourth issue about, or the question about the implications of certain approaches to the rule of law. Incidents or policies like no jab, no entry to the court can have greater implications on the state of rule of law. If we don't give access to litigants to come to court because they don't have jabs, then it does raise questions about to what extent does it abide to the need for rule of law to actually function still in the society if litigants decide not to get jabbed, does court refuse them that sort of access? So anyway, I will leave some of these thoughts here, and I will open to answering some of your questions. Thank you.
Thank you so much, Dr. Kama. That was really interesting, and I think the issue of accountability, the issue of respect for constitutional oversight and enabling that oversight, and the effect of laws that perhaps to some extent go around that oversight, very interesting, and also that oversight, the importance of it in the very broad-reaching health measures that are being undertaken, touching all aspects of people's lives. So thank you very much for those comments. And also, we will also be watching with great interest those court cases that you mentioned, and to see how the courts deal with some of these very important issues. I'd like to move on now. I'd ask you to perhaps keep your questions until all the speakers have spoken. So just jot down questions that you might have for Dr. Kama and other speakers as you go, and then we'll open it up to questions at the end. So I'd like to introduce now Mr. Bob Williams, who's the Secretary for Health in the Cook Islands. Over to you, Mr. Williams.
Thank you, Jean. A warm greetings and kia ora to everyone who have joined us on this meeting. The topic. To the speaker, just you.
Yes, we see you and we hear you.
Yeah, the topic that we are discussing today is timely, especially for us here in the Cook Islands. Our cabinet this morning has approved for our new border settings. And of course, strengthening legal preparedness and future response is critical as we watch our countries, nearby countries, the like of New Zealand, Australia, and others, who are moving away from the elimination strategies and moving towards suppression strategies, which is also critical for us here in the Cook Islands. So with the new norm, as we progress from the early of next year, that our journey for COVID safe Cook Islands will be the new direction for us here in the Cook Islands. And of course, we have identified gaps with the Public Health Act and also our international health regulations, which led the government to pass a COVID Act in March of 2020 to address some of the gaps with regards to contact tracing requirements, quarantine of travelers and individuals, wearing of masks, and other requirements that is required to ensure the safety of our people in the Cook Islands and those coming from overseas. So today I'm happy to present the Cook Islands experience with the role of public health and also other agencies, key agencies that are involved in our national response to ensure that we continue to be COVID-free. If I can have the next slide, please. So the Cook Islands was declared as the COVID-free nation on the 16th of April of 2020. And up to this stage, what the forward future for us will be starting to learn how to live with the virus, similar with the trends of other countries that are now embarking on. And with the new border setting from earlier next year, so there will be an amendment. Our Crown Law Office will be submitting to Parliament before end of the year for the necessary changes to take place before opening our border early next year. Next slide, please. So our success since for over the last 18 months has been under three main points. One, of course, is strong leadership, including our three main pillars here in the country, the government, and of course our traditional leaders, our religious leaders, to take the lead in terms of ensuring that the whole community complies with the requirements of the COVID Act and public health measures that have been put in place since last year and up to now. And secondly, strong public health measures that we've been putting in place with contact tracing and of course wearing of masks where required, and also the framework that we have put in place. We have suspended our border requirements several times. We engaged with New Zealand for a one-way quarantine-free travel in January of last year, and up to May this year, we have been having a two-way quarantine with New Zealand. And because of the COVID situations in New Zealand, so we have suspended several times of our two-way quarantine-free travel. And for the current Delta outbreak in New Zealand, our border has been closed for almost 9 weeks, up to now going on to 12 weeks. So including in the COVID Act is enforcement actions to support our preventative measures and also ministerial orders to ensure that people comply with the requirements when they are put into self-isolation or into a supervised or managed quarantine. Since then, we have charged 2 individuals under the COVID Act. One relates to providing false information to the Ministry of Health, and secondly, as of recently, as of last week, one is now facing charge for breach of the quarantine orders. because we have brought back 2 cohorts through repatriation flights over the last 3 weeks. And also as we prepare for another 2 managed returns for the coming month, for this month of November and 1 in December. There's been multi-sectoral support and response. One thing that we've stood up is we call it a PUNA system. PUNA system is we have several districts on the main island of Rarotonga here in the Cook Islands, where we have linked with the emergency management framework. So the Ministry of Health has worked closely with emergency management Cook Islands to stand up these systems and infrastructures to provide support for our communities within those districts. This will become very important for our new border setting, because should there be a positive case in the household, the whole household will be quarantined, and the support from this border system will be very important to provide moral support and other needs that is required for a particular household. And similarly to tourism, to visitors, when we open our borders early next year, the same process will be applied. So there will be a lot of sectoral approach, which will include our tourism sector and our business sectors with the requirements that needs to be implemented across the whole sectors of our community. Next slide, please. So with the current legal frameworks in place, as I mentioned, our Public Health Act, while it provides for the quarantine of ships and vessels and aircrafts, including passengers or crew. But what has happened is, as of this year, the COVID-19 Maritime Border Regulations 2021 was enacted. This is to allow, while our border is closed to vessels, but the regulation provides for exemptions to be provided. Example, like cargo vessels that needs to come into the country to bring in cargoes, or emergency flights that needs to come into the country for transit and go into another country, and likewise for other small vessels during cases of emergencies.
Just a time reminder, Mr. Williams.
Thank you. But there is limitations to the current act, and I would like to acknowledge Ben, Larry, and Dr. Chris Reynolds, who have also contributed to the development of our new public health bill. Next slide, please. With regards to the Ministry of Health Act, it does provide for powers of entry, inspection, and seizure, and contain drinking conditions. But the Act also has an overarching functions and responsibilities of enforcement, with the inclusion of police powers, but it is difficult to apply these powers in practice. So the enforcement powers provided under the COVID Act has been clearly outlined to allow our police officers to support our Ministry of Health in terms of responding to COVID breaches under the COVID Act. But the problem with the COVID Act is it's only valid for 6 months, and it has to be extended every 6 months. So with the new Public Act, Health Act coming into force, maybe in end of next year, that will override the existing COVID Act requirements. Next slide, please. The International Health Compliance Regulations, while it does provide specific arrangements for implementation, providing power to the Secretary to develop implementation plans, which we are also at the moment developing a pandemic response plan. COVID-19 has taught us a lesson that some of the plans that we had previously needs to be updated and revised to ensure that it captures not only for COVID pandemic outbreaks, for other future pandemic outbreaks that will be expected to come in the near future. And of course, the limitation is that the scope of the international health regulations and their relationship to other legislations and regulations is often unclear. And of course, it limits its practical usefulness when it comes to implementation. Next slide, please. So the COVID Act, as I mentioned earlier, was developed in March 2020. It is time bound. So that's why we are now proposing with the development of the new public health bill. Next slide. So Ben Riley and Dr. Chris Reynolds has been supporting the Ministry of Health, and I'm glad that our cabinet as of last month has approved for the bill to continue to progress to the next stage, and the timeline for its completion is 12 months. So we're looking about December next year, 2022, for it to make its way to Parliament for enactment. And this will provide more enforcement powers and increasing penalties, and also to capture other health risks that needs to be captured, and also for future pandemic outbreaks that needs to be considered now. Next slide. So the new law has these aims and objectives. It is outcome focused to address public health risks based on actual and potential harms. And the aim is to be a future-proof legislation that needs to look at health challenges over the coming years and decades. And of course, most importantly, is to protect our Cook Islands population from serious public health risks, and also to prevent acute support, health promotions, and the whole of society action on NCD. And it is planned to be inclusive, to include our communities, to be empowered to take part in decision making, and also to protect and promote the health of the wider community. Next slide.
Could we ask you to wrap up, Mr. Williams?
Yes, so finally, just like to acknowledge all the key partners that has been in support of the development of the public health bill. And of course, going forward, that will include all our national responses to future pandemic outbreaks. Thank you.
Thank you so much, Mr. Williams. And it really does, I think, assist everybody to walk a little while in your shoes and to see the different experiences from different countries, because we all learn so much from doing that. We're going to move on now to Dr. Posikai Samuel Tapo, who we didn't give his current title. He's the Acting Director General of the Ministry of Health Vanuatu, and we apologise for our error earlier. And over to you, Dr. Tapo.
Good afternoon and greetings from Vanuatu to all our colleagues in the Pacific and overseas. Thank you for giving Vanuatu this opportunity. I'm here in the room with the manager and the acting director for public health and the manager for disease surveillance and disaster within the country. So basically, I will run quickly into the questions that were put forward. And then from there, if there's any questions or any comments that colleagues want to raise, then they can ask it at a later date as per the remarks from the chair lady. Firstly, in regards to the public health emergency, the government of Vanuatu under the Public Health Act did an amendment to the Act and aligned it with the international health regulations. So there was the amendment CAP 234, which captures the declaration of a public health emergency that was not part of the Public Health Act that was amended in Parliament this year. And under the powers in the Public Health Act, it was more clear and more defined to isolation, for example, quarantine, giving penalties to those that breach quarantine and isolation, and also for the minister to issue regulatory orders to a specific agency in the event that we had to confine a ship, prevent plane from entering, or even confining or putting a group of people into isolation or quarantine. So it was limited to that area, but more clear and defined with the amendment of the Public Health Act. The Public Health Amendment Act was, as I mentioned earlier, was more aligned with the international health regulations. So in the event, not only for COVID-19, in the event that there is an increase in the threshold of a specific disease within country, then it signals a declaration of the Public Health Act, and then from there we respond. So it basically didn't only focus on COVID-19, but it also focused on other notifiable disease under the Public Health Act within country that can be declared as a public health emergency, and a response can be given. So within the Act, there are a few committees that the Act prescribes, the Amendment Act. That's members of the committee is chaired by the Director General, which is equivalent to the Secretary of Health in some countries. So he or she plays the chair. The members of the committee, the Director for National Disaster Management Office is the co-chair. The Director for Civil Aviation is a member. Director for Foreign Affairs is a member. The Commissioner for Labor, the Commissioner for Police, the Director for Immigrations, the Director for Customs, and the Director for Maritime and Ports. So that's basically the core members. The other members are invited to the committee meetings per the request of the chair or from the committee. So that's basically all the committee members that make up the advisory to them. What happens is that during a discussion of that committee, they make recommendations to the Director of Public Health, who plays the secretariat to that committee, and the Director for Public Health then advises the minister, and the minister issues a regulatory order in terms of quarantine, issuing a fine, or issuing an instruction to an agency to take specific roles or functions during under the public health emergency. So I think that's basically in regards to the first question. The limitations that we have within the amendment is that it doesn't really prescribe the powers that we can use to direct to police and other institutions. What we have seen also is that the National or DRM Act that we operate under, which is normally given to NDMO by the head of state or under the state of emergency, has more powers that can confine a specific group of people, at the same time give directions to police or the military to take specific actions. Under the public health emergency, under the Public Health Act, we don't normally have such powers. So it is something that we've been struggling in the few months, whether we should continue with the public health emergency or allow the response of the COVID-19 response or the pandemic to be under the SOE. So that is the limitations that we have. We are now exploring that through the state law office, just to see what powers the public health can also issue and can be equivalent in a way to the State of Emergency Act that is given to the NDMO. The NDMO Act doesn't really spell out this outbreak or this emergency. So we normally use their powers based on their control of an SOE in the country rather than a public health emergency. So it's a tricky area that we are trying to explore with our state law office to really draw a line in which powers the public health emergency can perform. At the same time, what powers are similar to what the state of emergency can give to the public health act. So I think that's the first one that we've been challenged with. Apart from that, we have managed to control the pandemic, and that's why we still have border cases with the support of the SOE and the public health emergency. The limitations going forward, as I mentioned earlier, we are trying our best to do a transition from the state of emergency, which is under the National Disaster Office, to the public health emergency. What the state law advises is that the public health emergency is more clear and that it can really spell out quarantine, isolation, if we are going to put people into quarantine, if we are going to prevent the flight because of a specific disease. It clearly spells it out compared to the SOE. What we are doing now is they're trying to really explore the powers that the Public Health Act can use in the event we have to control agencies, which that area is still yet to be explored compared to what the SOE can do. So I think that's the challenge or the limitations that we have under the Public Health Act. The government has decided that the SOE will come to an end at December 31st this year, and we will transition to the public health emergency. And during that time, it will be under the Ministry of Health leadership, and the minister will be the one that will be issuing regulatory orders. Today, it is still under the disaster office, which is headed by the director for NDMO. Major lessons that we have learned. One classic example was when we wanted to conduct simulation exercise. The police could not participate. The police did not participate because they advised us that under our law, the public health emergency law, we could not instruct them, or it was not really clearly spelled out. So that is the challenge that we have right now. Even though we can declare a public health emergency, we still do not have much clarity in our law that can direct a specific agency like what the SOE under the Constitution does. It can direct a specific agency to do what, it can confine or stop a ship or stop an aircraft. But for public health, amendment public health, it is not clear. So I think that is the major lessons that we have learned. We are thinking of going back to Parliament just to do an amendment to give more powers to the Public Health Act. Currently, the limitation is that the Public Health Act under the minister's regulatory orders can issue, but whether it has more weight to direct a particular agency to participate, or it can direct businesses to close their door, that power, compared to what the Constitution does under the SOE, we find it that the Public Health Act doesn't have much power. So I will also allow guidance from all our other Pacific Island countries that also have implemented a similar or other laws in terms of pandemic or health emergency, and they can also guide us going forward. So it's a very tricky area that we are faced with now in terms of whether we continue using the state of emergency law going forward, which doesn't really specify disease outbreak, but just because it's confined under the Constitution, it limits specific rights to people as well, or we will move to the Public Health Act as of December 31st, and then we will start issuing regulatory orders to agencies to confine the disease or to control the pandemic in the event that we have community transmission or sporadic cases. So I think I will leave it as that unless my colleague have any few remarks to add. Yeah, so that's basically where we are now. It's the struggle of power between the SOE and the public health emergency. Even though we declare a public health emergency, whether the public health emergency has more powers to control agencies like the police, the airports, yes, even though the minister under the act has regulatory orders that he can issue, we have tried it and it seems to be more people, I can say more people believe that the Constitution is the one that can make decisions to control people in a certain way or control situation in country compared to the Public Health Act. So it's a tricky area as we are exploring it going forward, but any guidance and comments from all our family and friends in the Pacific can also guide us in terms of whether for the ministry we move to the public health emergency or we stick to the state of emergency under the NDMO, which is affiliated with the Constitution. I think I will leave it as that, and if there is any comments or questions, we can ask it. Thank you, Jenny.
Thank you so much, Dr. Tapo. And I think that you've really neatly encapsulated three of the issues that so many countries are grappling with. And I think you've done it in a really clear way. So One of them would be the importance of a use of a multi-sectoral mechanism, so your National Disaster Office and your National Disaster Act, and the importance of bringing in all of those relevant sectors. And you seem to be describing a mechanism that worked there. But then there's the issue of lines of authority and lines of accountability when you shift your use of law from one relevant law to another as a risk escalates, and then as the risk starts to reduce again, different powers might be needed and different criteria trigger different uses of law, and you are working as best you can through how those laws might be used together, and also laws that were drafted in Vanuatu, as they were in so many countries, probably without a pandemic of this kind of scale in mind. And the third one was, what are the limits of the available power, and how do you manage, say, under the Public Health Act, and what the available limits of the power are, and whether you harness powers under other laws, and how all of those fit together. So I think that you've really neatly and helpfully, I think, outlined a lot of issues that are shared across many countries, certainly in the Pacific, but also more broadly throughout the region. So thank you very much. And we'll wait again until the end. I'm sure that there'll be questions, but I'd like to move on now to introduce Ms. Manti Charlton, and over to you, Ms. Charlton.
Thank you and good morning. Just confirming that you can hear me okay. Yep, fantastic, thank you. And the Secretariat does have the slides for my presentation, but in brief, I'll be focusing on Australia's Biosecurity Act 2015 today and the ways in which we have used that piece of legislation to support Australia's COVID-19 response. So moving to the next slide, the Biosecurity Act commenced on the 16th of June 2016, so it is really quite new legislation, and it replaces the Quarantine Act, which was in effect for over 100 years. And you can imagine that being a 100-year-old piece of legislation, it was written at a time where we did not have international air travel at all, and we did not have the speed of travel that we currently have today, so a very different sort of context. So our new legislation, the Biosecurity Act, was developed with that in mind, and it has a One Health approach in that we jointly administer that within the Department of Health and also with our Department of Agriculture, Water and the Environment. So being a new piece of legislation, it was the first opportunity to test a lot of our powers throughout the COVID-19 pandemic, and we've used just about everything in the book there in responding to this public health threat. There are a number of limitations within the Biosecurity Act that ensure that we're appropriately using that legislation, including a requirement that there's a strong public health rationale to be able to use those powers, and some specific principles of general protection outlined within the legislation itself. Moving to the next slide. And this is a little bit of additional context too of the Australian environment. We have 3 levels of government. So the Biosecurity Act is at that first level, the federal government. And our state and territory governments have primary responsibility for public health, including Australia's quarantine requirements. So our Biosecurity Act has primarily been used in developing and implementing national policies and requirements, including specifically at international borders. Moving to the next slide. Our Biosecurity Act is used both for business as usual purposes, so outside of the COVID-19 pandemic, and you can see a few examples of where we use those powers in that first box there, but it also gives effect to some of our requirements under the international health regulations, including ship sanitation, vector monitoring at points of entry, and those sorts of things. It is used for pre-arrival reporting, which is one of the most important things in terms of being able to early identify a public health threat on board an incoming aircraft or vessel. We also have a range of emergency powers, which we've used for the pandemic, as I've mentioned, and some of those are outlined in that second box. So I'll go into a little bit more detail in the next slide, but you can see there's a range there of different powers that we've used, particularly at international borders, to be able to address those public health threats. So we might move to the next slide. So this is a bit of a depiction of the consultation processes and the considerations that we must use when we're using those emergency powers. So you saw on the previous slide some of the examples of the things we've done. but this really steps out that kind of process that we need to go through when considering it. And that first step is actually making sure that the disease that we're wanting to use the powers in relation to is specified under our legislation. And those diseases are really quite serious diseases that don't have endemic transmission. So we're thinking about pandemic influenza, obviously pandemic potential coronaviruses, those sorts of really serious diseases that we don't have within Australia and that we are looking to keep out. As an island nation, Australia does have a good advantage in that we don't have land borders. So if we don't have the disease enter Australia, then there's not an opportunity for it to transmit within our population. So that's that first step there, is making sure that it is a disease of concern specifically legislated under that act for us to be able to use those powers. In the second step, and this was our first time doing so, we can declare a human biosecurity emergency period. And to do that, we need our Governor General to be able to make that declaration. It's a legal instrument based on advice from the Health Minister, and the Health Minister forms that opinion based on the extensive health committees and experts that we use within Australia for all of our public health decision-making processes. So that declaration was made in March 2020 and remains in place now. It's currently in place until the 17th of December, but the government is considering whether it is necessary to have a future extension of that period, and we can only extend it by 3 months at a time. So that's one of those mechanisms to make sure that we're not using powers inappropriately and that they're proportionate to the public health risk. In step 3, you can see that the Health Minister can make any requirements necessary to meet the public health risk once an emergency is declared. So the Health Minister has exercised these powers, I think, 8 times in total during the pandemic for different issues, but some of those different emergency determinations have been amended a number of times as needed to meet the different kind of changing context. And once again, we use our specialist and expertise committees across the sort of federal and subnational government levels to be able to inform that decision-making process so that we're getting the right public health rationale and advice to be able to support the decision-making. And part of the intent is that we're not just providing ministers with powers to do things, that they actually do need to be using those professional clinical judgments to be able to exercise them. So as I mentioned at step 4, the human biosecurity emergency period can only be in place for 3 months at a time, but we can extend it. And we have done that a number of times since its first implementation in March 2020. But there will be a point in time in the future where we no longer have those emergency powers. And one of the things that we're internally considering is what that means for the emergency determinations we have in place now, and whether we still want to be giving effect to those restrictions and requirements through other settings, including other legal instruments or other policy options. So moving to the next slide. In responding to the future needs of the COVID-19 pandemic, and as I've outlined, this is the first time that we've used a range of these powers. So it is a real opportunity for us to be able to learn what they look like in practice. We have prepared for this pandemic in that we've written policies and work instructions and guidance materials, but nothing is quite like actually doing it in practice. So we have a lot of things that we have learnt through implementing these powers that could be improved or could be better done. And we're keeping a track of all of these so that once the initial pandemic response and the initial need is over, we can continue to review these and have a continuous improvement process underway. Our joint external evaluation in 2017 did positively reflect on our legislative framework, but as I've mentioned, in actually using the powers, we've discovered things that weren't picked up in the JEE and that would only really be picked up during an actual use of the power itself. So I mentioned that we're keeping an internal register of these lessons and these opportunities for improvement, but we all are also amending things as we go along if there is an immediate and pressing need. And one of these amendments is before the Australian Parliament at the moment, and that's the Biosecurity Amendment Enhanced Risk Management Bill. And that bill is specifically looking at the risks posed by cruise vessels. So one of the biggest outbreaks in Australia early in the pandemic was the result of a cruise vessel entering Sydney Harbour with hundreds of cases on board, and those people then went into the Australian community and also travelled internationally. So we've used that lesson to implement some improvements in how we might have additional pre-arrival reporting requirements for cruise vessels, increasing the penalty provisions for the people who don't comply with some of these requirements. So if a vessel wasn't to meet the Australian government requirements, that we can apply a bigger fine to them, and also to provide some new opportunities to be able to direct groups of people differently. We're also, I suppose, fortunate enough that we are being audited independently by the Australian National Audit Office. And those audits are a really good objective way of identifying where there's additional lessons or improvements that could be made, not so much in the legislation itself, but in the consultation and the implementation of that legislation. So obviously, no department can do everything themselves, and we do rely quite a lot on our other government agencies, including those that have a physical presence at international borders, such as the Australian Border Force and our Department of Agriculture colleagues. So where we might have opportunities to strengthen our relationship with those agencies. We might go to the next slide. I might talk a little bit briefly about the different mechanisms that we have used these emergency powers for. And I mentioned cruise ships. Cruise ships in Australia are currently prohibited from entering the Australian waters. They're not able to operate within Australia if there's more than 100 passengers on board. And you know, a lot of real strong restrictions on that. And that's because of that first experience with that vessel and the potential for cruise vessels to have a large number of cases on board. And we don't want, you know, there to be an outbreak on board and then entering that Australian community context. But at some point in the future, particularly with Australia's vaccination coverage increasing quite strongly, we will be looking to remove those restrictions. Also, one of the Australian government restrictions is on outbound travel of Australians. And this has been quite a controversial one, and not one that a lot of other countries have used. But as I mentioned, as an island nation, Australia has got an opportunity that countries with land borders don't necessarily have, in that we can really strongly control the entry and exit of diseases through controlling those sorts of international movements. So since March 2020, Australians have been restricted from leaving the country unless they have an exemption or they fit in a very specific category. And on the 1st of November, we made our first steps towards removing these restrictions by allowing fully vaccinated Australians to leave without getting an exemption. So we can
time reminder.
Great, thank you. So we are continuing to restrict the movements of unvaccinated Australians, both to protect the Australian community when these people are returning, but also to protect those people who are at higher risk of themselves contracting COVID. And probably the main other one I'll mention is our pre-departure testing requirements. Like many countries, Australia does have a requirement that travellers to Australia provide a negative PCR test within 3 days of departure to come to Australia, and that's sitting under our emergency powers. But that's one of those mechanisms that we are wanting to consider an enduring process for, because it is something that we do see as being important into the future, whereas things like cruise ship movements and the outbound movement of Australians are things that we do know that we are going to be looking to reduce and ease those restrictions in the near future. So I think that will do with that for me. Thank you. Happy to answer questions when we get to question time.
Thanks so much, Ms. Charlton. And it's been really interesting. This is the third country experience that we've just heard about, and so interesting to hear how different they are, and yet you know, some areas of similar challenge as well. Just noting a few things there that I thought were of particular interest. The One Health approach, which I think is and the co-administration by a number of sectors, I think is very much worthy of note. Also noting that of the available powers that were put in place pre-COVID, that you've used almost every available area of power. Again, very interesting. Noting also the need to review in real time, and probably at the end of the COVID as well. And so many countries, I think, will be similarly thinking about how their laws went and how they might review them towards the end and at the end of the COVID pandemic, and also noting in that respect as well the importance of accountability and in this case the the Department of Audit that also provides that accountability. So thank you very much. Now we'll move on to Dr. Lu Yang, and over to you, Dr. Yang.
Can you hear me? Hello. Good
Yes.
morning, good afternoon. Okay. Good morning, good afternoon, good evening, every colleague. I'm Liu Yang from the Legal Department of National Health Commission of China, and very glad to have this opportunity to introduce you how China did on the basis of law to make measures to control the COVID-19. And COVID-19 is a global pandemic, is the most extensive to afflict humanity in a century. And facing this unknown, unexpected, and devastating disease, China launched a resolution battle to prevent and control its spread. Making people's lives and health its first priority, China adopted extensive and thorough containment measures. And in the past decades, China has made many laws relevant to public health. For example, we have national statutes such as emergency response law, law on prevention and treatment of infectious disease, law of frontier health and quarantine. And we also have administrative regulations such as regulation on response to public health emergencies. And we have administrative rules such as rules on law on prevention and treatment of infectious disease. And we have policy documents made by the State Council or the government agencies, like measures on public emergency management plan. And there are local regulations and rules as well. All the laws and regulations strengthened legal safeguards for the epidemic prevention and control. During COVID-19, China took measures to control and prevent epidemic on the legal basis. For example, according to the law on prevention and treatment of infectious disease, the infectious disease are divided into class A, B, and 3, and C. And the law provides different control and treatment measures for different classes of infectious disease. In the last year, China listed COVID-19 as a class B infectious disease and addressed it with measures applicable to a class A infectious disease under the law on prevention and treatment of infectious disease. And it also applied control and quarantine measures under the Frontier Health and Quarantine Law, consistent with relevant provisions and international law and other domestic laws. The standing committees of some subnational people's congresses, like the congresses of different provinces, they launched emergency legislation procedure as per the national legal framework, empowering local governments to introduce interim emergency administrative rules relating to healthcare and epidemic control. And the law on prevention and treatment of infectious disease and measures for its implementation have been strictly enforced. And the guidelines have been made on controlling the disease, combating epidemic-related crimes in accordance with the law, and protecting people's life and health. Law and order and market supervision have been strengthened, and stronger measures have been taken against deceptive and illegal advertising, ensuring social order and stability. And the supervision on administrative law enforcement have been intensified during epidemic control to ensure that the law is enforced in a strict, impartial, procedure-based, and non-abusive way. Legal disputes associated with the epidemic have been resolved in accordance with the law, and legal guarantees and services have been provided for COVID-19 response and for business returning to work. And the government has also made great efforts to raise the public legal awareness and guide people to act within the parameter of law. And listing COVID-19 as a Class B infectious disease and address it with measures applicable to Class A infectious disease under the law provide legal basis to take strong legal measures to control sources of infections. According to the law on prevention and treatment of infectious disease, the Chinese government defined a set of requirements: early detection, reporting, quarantine, and treatment, with a focus on 4 categories of vulnerable people, like the confirmed cases, suspected cases, febrile patients who might be carriers, and close contacts. It had also taken measures to ensure that they were hospitalized, treated, tested, and quarantined as appropriate. It has done everything in its power to reduce infections to the minimum. And China has provided information on COVID-19 in a thoroughly professional and efficient way. It has released authoritative and detailed information as early as possible on a regular basis, and thus effectively responding to public concern and building public consensus. And a strict system of information release have been established according to law on prevention and treatment of infectious disease. China has released information on COVID-19 in a timely, open, and transparent manner as required by law, and strict regulations are in place to see there is no withholding of information or delay in reporting cases of infections. China has shared information and experience with the international community, and China has provided support for global virus prevention and control by sharing information and experience with the international community. And now China is improving the legal safeguard for public health. And the Standing Committee of National People's Congress worked to establish stronger legal safeguard for public health and developed a work plan for enacting new laws and revising existing laws in a timely manner, and formed the task forces to advance the enactment or revision of 30 pieces of legislation in batches, like we are going to formulate the law on responding to public health emergencies, and we are revising the wildlife protection law, the law on prevention and control of infectious disease, the frontier health and quarantine law, and the practicing physician law. Responding to the sudden outbreak of COVID-19, we focused on developing a better coordinated and interconnected legal system and speed up the enactment and revision of laws to strengthen the rule of law with regard to public health. By improving relevant laws, raising legal awareness, and promoting greater compliance, we worked to ensure that the release of information on COVID-19, the allocation of emergency supplies, the handling of social issues and disputes, and the maintenance of order in the market were all carried out in coordination with the law, and thus using the force of law to protect the health and safety of our people. And in the future, we calls on to build an efficient and sustainable global public health system for the benefits of all humanity. And China therefore calls on the international community to draw lessons from this pandemic, and the countries should show extraordinary political vision and a strong sense of responsibility by doing following things like embrace a philosophy that puts life above everything, and establish sound mechanism for international cooperation, and create an efficient, sustainable global public health system for all, and build a global community of health for all. And this is my presentation. Thank you.
Thank you so much, Doctor. That was very comprehensive and very helpful. And I just noticed a number of really interesting points that you made that I think enrich our conversation greatly. So noted the extensive laws that China had passed in relation to the management of public health risk and health emergencies. Noting your helpful description of the classification of infectious diseases into different classes, and a lot of countries have those kinds of things, and I think very helpful during COVID-19 to be able to trigger the various measures that were needed to be taken. Also, there was a very important point I thought that that needed to be made about the importance of the different functions of the national and subnational levels of government and the use of law at those different levels. And obviously China is a very big country, and the use of laws at the subnational level would have been very important. Noting also what you said about the management of communication and its importance, and the use of protections also around the use of law. So also very important. Noting what you said also about the efforts that the government made to let people know what was happening. Certainly, we've noted as we've been moving through this pandemic and communicating with countries that a lot of countries struggled sometimes to get information out to people to understand what was happening and why. So noting that the Chinese government tried very hard to achieve this. Also, noting the importance of regular updates, and also that that China's already working to review existing law. I think a lot of countries, I think we said after some of the other presenters, a lot of countries are reviewing and monitoring the use of law during COVID-19, and we'll think about it again afterwards. And also noting China's calling on countries generally to learn lessons from the pandemic, and I think that very timely communication, and I think definitely what we are trying to do in relation to this forum. So, Dr. Yang, I want to thank you very much for your intervention, and then we'll move on to Mr. Fazu, and just noting that we're running a little bit behind time, so we'll be most grateful, Mr. Fazu, if you can try to stick to time.
Thank you.
Apologies, Genevieve. Just confirming if you can hear me, please.
Yes, we can. Thank you.
Requesting if I can please share screen as well. Requesting if you can confirm that you're seeing the presentation on the screen, please.
Not seeing a presentation. I'm seeing the overview of the forum. Now we see the presentation. Thank you.
Thank you. Apologies, but I'll try and turn off my camera, basically because of issues with I think it's gone back to the other screen. Anyways, okay. So I guess I would just like to say thank you very much for the wonderful discussions today, and definitely it's been great to hear from everyone on the work that they have been doing with regards to response to COVID, and perhaps also reinforce some of the messaging from from the foundational work that was done earlier on with regards to response to disasters. And I think listening to the countries, I just wanted to touch again on some of the similarities or some of the issues that are common with regards to COVID-19 and other disasters that has been experienced in the region. As you may be aware, the Pacific is home to a number of hazards, and with climate change, there's a lot of issues that, or a lot of disasters that they have been exposed to. Give you a little bit of a snapshot. Since 2012 to 2016, Vanuatu and Tonga have been first and second as the most vulnerable countries in the world to disasters. In 2019, Tonga slipped down to 3, while Vanuatu maintained first. In 2020, Vanuatu and Tonga became first and second again. And this year, 2021, Vanuatu is the first, Solomon Islands is the second, and Tonga is the third. And what I'm trying to emphasize here is because of the rich history of responding to disasters in the Pacific region, there have been lessons learned over time that can translate across to a lot of disasters. Although, as from the discussions that we've had today, not totally applicable to all types of disasters or addressing all types of emergencies. There are some constants there that you normally take into consideration in times of response. So I'll quickly just click through or what's on the, confirming if you see the second slide, please, Genevieve.
Yes, I do. Thank you.
Yes, so I mean, just looking at disaster law in general, I think it was emphasized earlier on that you need to ensure that our laws and what's in place address legal preparedness. And this is for regulation of international assistance, looking at a cross-sectoral approach. And of course, in the beginning, climate change and DRM was one of the key themes in the Pacific until COVID-19 came in, and then the public health emergency became, I guess, one of the issues that everyone's turning to. So risk reduction across all sectors, no matter what type of hazard or disaster you're looking at dealing with, is something that needs to be addressed in all types of emergency and disaster laws. And of course, as pointed out by our presenters today, knowing your rights and especially the roles and responsibilities that each and every one has to play in times of disasters. These, as you see before you, are some of the studies that have been undertaken to support a number of these developments in the region as well as in the world. And a new one there is the Law and Public Health Emergencies study, which was just conducted during COVID-19 time. And we would like to thank WHO for their participation in the international launch and launch in Asia. And of course, we're hoping to also launch together in the Pacific in the coming weeks. I guess one of the key things that we realize here, and just like the disaster laws themselves, is that a number of the laws and policies that we have in place are a bit dated. And there is a need, I guess, to move on in terms of reform. And that is something that I realize we have all agreed on with regards to moving this work forward. As identified, there's not really a lot of international treaties or agreements that comprehensively look at disasters or regulation of emergencies, other than international humanitarian laws, the health regulations, as we've been discussing today, and the refugee laws. However, there are sectoral legislation, and this comes out in a number of discussions that we've had today, that we need to kind of like coordinate across sectors to take an integrated approach for a successful response. So for instance, in a lot of the discussions that we've had today, there have been discussions with regards to the involvement of customs at the border. And of course, at the international level, you would have the Kyoto Convention, the revised Kyoto Convention, Annex J5, which provides for the clearance of disaster relief in times of disasters, and then the types of concessions and exemptions that are provided. The Tampere Convention with regards to looking at dedicated telecommunication, allowing comms equipment to be brought into the country and to be used. The Food Assistance Convention, which provides that the basket that is provided in times of disasters have to be ensured not to be empty calories and have to have a certain nutritious content. And in the Pacific, the key things that occurred due to the fact that geographic nature in the Pacific being maritime, looking at the Chicago Convention and of course the Convention on Maritime, the movement of goods across the oceans and into the Pacific. So another IDR checklist, and I guess this is an area where a number of you may have also dealt with in work in the region, is just looking at with the close downs, and this is because of the Spanish flu that occurred in the Pacific, the rich history of the Pacific and pandemics, and I guess out of that, more than 20% of the population in Samoa were decimated. And during the time of the pandemic, when COVID was starting to emerge, Samoa had also undergone, I guess, an epidemic of measles. So there was around the region also outbreaks of measles, and there was a lot of wariness within the region with regards to a pandemic or infectious diseases. So when COVID-19 started emerging, you will notice that a lot of the Pacific Island countries, and this is after an assessment of their health regulations and their health laws, they actually shut their borders as a way of minimizing the risk and as a way of ensuring that they are not affected. And because of that, there was not as much, I guess, badly effect in the countries in terms of the disease itself or the pandemic itself, except for, of course, those whose borders were open, as we heard from PNG. But there were other effects and there were other problems. And this is something that came out in some of the discussions that we've had, including the presentation from our colleagues in Vanuatu. And these issues would be economic issues. And there were also issues of, because of the lockdowns, there was an issue of immobility, and there were a number of people who were then stranded. And this is where I guess the importance of looking at an integrated approach with regards to disasters is required, so that we can all come together in the different sectors and assist each other. I guess we all agree that there is a need to improve our laws, both in the health sector and as identified also, disaster risk management laws, and then the laws with regards to emergency declarations, and as identified by our colleague from PNG. This is where there needs to be a closer look at what powers you are using. And because of the strict requirements on the use of emergency powers under the Constitution, and because of the effect it has on human rights, as pointed out by our PNG colleagues, the term for that particular declaration is a bit limited. However, if you have alternative, I guess, laws in place for other declarations, as pointed out by our colleague in Vanuatu, then the extension can be a bit wider. And this is where I guess, thank you. I noticed that my time is almost up.
Yeah.
But I guess to finish off, I just wanted to say that the approach given by a number of the countries shows that there is a need for us to come back together again and to look at a better way of moving things forward. An integrated approach is required, and integration here doesn't have to be under one legislation. It's just having a cross-sectoral understanding of the roles and responsibilities in protecting the country, in protecting your borders, and also looking at the approaches that were put in place that can be used again in the future, like Cook Islands having a sunset clause and the law they put in place as a placeholder until COVID-19 passes, or a better law, well-drafted law is brought out. But a great approach here is the approach that was given by Australia as well, very comprehensive, sending out the powers. And of course, you have those powers under your customs laws. So if you don't have that act in place, you have those laws through a sectoral approach that you can utilize in the time being while you're working out more with regards to quarantining people who arrive in on a ship. Apologies, the time is quite short. It's a very, very great discussion, and I'm elated to be here and to learn from everyone. Thank you very much, Genevieve.
Thank you so much, Mr. Fazo. And I can see how you tried so hard to fit as much as you could into the available time, as everybody did, I must say. And I am grateful to all of you. Just in relation to what you just said, I think it was really helpful at the end of the session like that to bring us back to the perspective of disaster risk management and to look at it also from a regional perspective, and noting also what you said about the importance of assisting in each other. And of course, you're right. And also you made the point quite rightly and echoed some of the thoughts from our colleague from Papua New Guinea about the importance of those disaster management laws connecting back to the Constitution and being the importance of them fitting within the parameters set by constitutions and the oversight in relation to powers that are so broad within the community. Now, we are going to allow 10 minutes for questions. We have gone well over time, and my sincere apologies to everybody for that, but we did want to allow at least a little bit of time. So if anybody has a question, please put your hand up within the, using the reaction section in Zoom, and I'll just look to see whether there are any hands. I'm not seeing any at the moment. All right. Well, if there aren't questions, I think that that we can wrap up. It's been an incredibly detailed and I think incredibly useful session, and I've been enormously grateful for the contribution of each of our expert panelists, and I want to thank you very, very sincerely for that, for giving your time to us today, and to join with your colleagues in the region for that purpose. So I think I'll pass it back to you, Jonathan, and you can take it from here. Over.
Genevieve, I did see a hand go up then. Just.
I'm so sorry. I missed that. I'm so sorry.
So, and
I'm not seeing the hand.
Yeah, it's disappeared. So I can't see now. So sorry, go on.
I think I've seen a hand from Prakash.
Yeah, that's what I saw that too. So
thanks, Jonathan.
Okay.
I raised a hand and then realized let's discuss. But my question to a presenter from IFRC and China is, if I need to understand what are three major strengths and major weakness which the communities in Asia and Pacific could learn from experience in China and IFRC experience in the Pacific, would be good to discuss.
Thank you, Genevieve. Would you like me to go first?
Please go ahead. The question was to you, I believe.
Yes. So I guess as we tried to point out, with all disasters, there has been ongoing capacity building within the region. And with the cyclone season coming up here in the South Pacific, there has been a lot of training going on to build the capacity of the communities in response in case of a cyclone occurring. With COVID-19, of course, that brings a lot of other, elements to it as well. And that includes putting in place a SOP for how you respond to a disaster while there's a lockdown or there is a community case. So as mentioned before, there is a lot of best practices that we can build on, those linkages from the national down to the subnational and right down to the community level. So that linkage is through your national society, Red Cross, Red Crescent branches in terms of building that capacity, and then building on that and adding the other requirements that you have. You already have requirements there with regards, because you normally after disaster, you would have other outbreak of diseases or vector diseases. So you have best practices already there under WASH protocols for how to wash your hands, how to sanitize, and how to treat water before you consume in times of disasters. So it's building on those experiences and what's there, to adding on and tweaking it in relation to the best standards or what comes out of the WHO advisory in terms of increasing, I guess, diligence with regards to those already in place SOPs, and tweaking that to address the new emerging issues when it comes to disease outbreaks. I hope that kind of answers the question. And here again, it's the capacity building, it's the tools, it's something that continues and is ongoing, both in post-disaster as well as in the preparedness phase. Thank you.
Terrific. Thank you so much. And unless I've missed any more hands, I can't see any. I'll hand over to you now, Jonathan. Thank you so much.
Okay, thanks very much, Genevieve, and to all our panelists for a fantastic session. We're going to take the 15-minute break now, and so we'll return at what will be 11:40 Manila time for session 3, which is on digital technologies in the COVID-19 response. So thanks so much, everybody, for a great session, and see you back here in 15 minutes. Hey, welcome back, everybody. A reminder to those who are joining the forum by Zoom that we're live streaming the event on Melbourne Law School's YouTube channel, and we're recording it, and it will be posted on the university's website soon after it concludes. So it's over to session 3, which is use of digital technologies in the COVID-19 response. And I'll hand over to Ben Lilly from Wipro, who'll be moderating this session. Over to you, Ben.
Thank you, Jonathan, and good morning, afternoon, and evening, everyone. So I'll be your moderator for session 3, which will focus on the use of digital technologies in the COVID-19 response. Next slide, please. So this has obviously been in an area of rapid development and discussion in the COVID-19 pandemic. Excited to be joined today by a panel of experts with a really wide range of experiences and vantage points to help us explore the topic and identify lessons for the future. So we'll be joined by Associate Professor Mark Taylor from the Melbourne Law School at the University of Melbourne and Director of Research with HELEX, which focuses on the legal and regulatory frameworks governing new technologies, and by Dr. Pura Angela Wico, who is the Philippines country manager for ThinkWell, which aims to translate global commitments into creative, practical, and bold solutions for achieving UHC. By Tenzi Yao, legal director at the Singapore Ministry of Health, who was involved in the implementation of laws to facilitate digital contact tracing and technological approaches to surveillance efforts during the pandemic. Dr. Vieng Savang Kitipong, Chief of the Surveillance Division in the Ministry of Health of the Lao People's Democratic Republic, who was deeply involved in surveillance efforts during the pandemic. And finally, Kyle Young, who was a consultant with our health board ethics team, and with whom we have worked closely to develop guidance on digital health issues during the pandemic, including the use of digital contact tracing and quarantine tools. Next slide, please. So just very, very briefly, I just want to take you through a little bit of the background context here. So, potential for advancements in digital technology to improve health are apparent, and they're already being realized in several areas. In its resolution on digital health, the World Health Assembly recognized the potential of digital technologies to advance the SDGs, and in particular to support health systems. But at the same time, it acknowledged the significant legal dimensions, particularly with respect to data use, and the World Health Assembly urged member states to develop appropriate legal and policy frameworks. Next slide, please. Realizing the potential of innovation in digital technology for health is also a key feature of the WHO Regional Office for Western Pacific's for the future strategic vision of the healthiest and safest region. Next slide. So the COVID-19 pandemic has seen a rapid proliferation and expansion of digital health technologies. I'm sure you're all well aware. And some of those have been novel, some emerging, and the specific conditions of the COVID-19 pandemic, including the demands it placed on health systems, stimulated interest in experimentation among governments and created a new market for tech companies. It's fair to say that during the pandemic, we've observed both the potential as well as the limitations and risks of digital health technologies. Next slide, please. Some of the technological
and I suppose public health themes that we observed that were relevant include that personal information has been central to surveillance and response efforts. The technological advancements such as big data have allowed a rapid increase in the capacity to extract and to analyze data, changing the risks associated for individuals and communities. There's been a need to share information quickly across multiple actors in the health system and beyond, as well as across jurisdictions as well, something which was covered by a number of the speakers during the last session. And the private sector has played a significant role as technology providers, as service providers, and as users. And it's also seen a highlighting of the digital divide that we know exists in our region. Next slide, please. I mean, in terms of the things that we observed that were more related to the role of law in this space, I think we've seen reinforced that law can function as a barrier or an enabler to innovation and the appropriate use of digital technologies. The legal dimensions of digital technology for health are numerous and multifaceted. There are several laws and legal domains involved, including privacy, service regulation, medical device regulation, intellectual property, and the list goes on. And it's also worth saying as well that legal frameworks and approaches remarkably across our region due to a range of factors, including culture needs, and a universally correct approach. We have seen, though, in our region, I think it's fair to say in most member states, the law did catch up to some extent due to a combination of frameworks in some countries, as well as some of the technologies being novel or emerging, and was yet to contemplate them. And finally, next slide, please. Finally, one thing that we observed was the importance of both the digital technologies as well as the response efforts generally. Many technologies, particularly those that rely on user acceptance and uptake, exhibit a network effect phenomenon, where uptake affects effectiveness. Media so just before I panel, I thought we'll just next slide.
Sorry, Ben, I think we're losing you.
Yeah, I wonder if I should jump in here and yeah, Ben, oh, sorry about this, everyone. I think Mark Taylor Mark, you were first on as the first expert panelist. I might invite you in now, Mark.
Okay, thanks, Jonathan. I'm sure we'll hear back from Ben when the connection reestablishes. Good morning, good afternoon, and good evening for me. And thank you all for inviting me to be part of this important and interesting event. I'd like to start by acknowledging that I live and work, and I'm speaking to you now from the land of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past, present, and their emerging leaders. So this panel, as Ben just said, this panel is concerned with how legal frameworks can support the use of digital tech in a pandemic response and how it has done in relation to COVID-19 in particular. I'm going to focus in my short remarks, I'm going to focus on the use of that digital tech in the hands of citizens and consumers, specifically thinking about the kinds of apps which people have been encouraged and in some circumstances required to download onto their mobile phones, and the apps which have been used to monitor location, exposure to contacts, cases, register vaccination status, etc. That kind of digital tech is the object of my concern right now. So how can a legal framework support the use of such apps and enable, noting as Ben just said there, legal frameworks can both act as barriers and as enablers. How can the law here act as an enabler and enable data to flow to support the kind of public health response we're looking for? Well, particularly when we're dealing with the kind of digital tech that I'm concerned with, the tech which consumers are relied upon to use, to download and make use of on their own personal devices, I think that the answer to that question, how can a legal framework best support use, is by best supporting the conditions of trust and accessibility. Now, trust and accessibility are both important. Ben noted in his introductory remark just before we lost him that there's a direct relationship between trust and effectiveness in this context. The use of digital tech in the hands of citizens is going to be more effective. The data you're going to get is going to be of a higher quality if people are able and willing users, if they're motivated by a sense of collective benefit, a sense of solidarity. Accessibility kind of speaks for itself. You have to be able to take account of varying levels of digital literacy. The apps have to be available to people. They must be able to download them and they must be able to use them. And that means in part that they must be present information in a language which is accessible, both an appropriate, accessible in all manner of ways, not least of all with regards to the language which is being used. So as well as accessibility, we are concerned here with how legal frameworks can support trust. And I'm going to draw that distinction that Honora O'Neill makes very clear in her work between trust and trustworthiness, and suggests that what the legal framework should be trying to do here is promote trustworthiness rather than trust per se. So what does trustworthiness look like in this context? Well, the literature on trust and trustworthiness tends to call out three different features that are associated with entities and organizations and operations that are perceived to be trustworthy. They relate to competence, to integrity, and to benevolence. So if we want the digital tech to be trustworthy, it has to be perceived to be competent. Now, that's not just about it actually functioning as it should. I mean, there is a technical answer to this. Does it actually work? There's also a social answer, which is a social aspect to this, which is about whether or not people perceive there to be a risk that the digital tech can actually guard them against. This is about whether or not it's technically functioning, but also whether or not people think it will work to protect them and those that they care about from a health risk, which is in part about the perception of that risk, as well as it is about the extent to which the app or the device itself is going to work to protect them from that risk. So there's a technical aspect to competence, there's a social aspect to it, but there's also a legal aspect. And there was some concern in relation to at least one iteration of the contact tracing apps that was used in the UK, that the governance arrangements that set up around the app might actually have affected its effectiveness by denying to NHS contact tracers the telephone number of those that they might otherwise have been able to reach out to and follow up with for contact tracing purposes. It was intended to prevent that access as a privacy protecting measure, but it actually arguably interfered with the effectiveness because people couldn't be followed up by contact tracers. And when people were given the opportunity of voluntarily providing a phone number for that follow-up call, in Ireland, 80% of people who were given that opportunity actually took it up. So we have to ensure not only that these systems work technically, that there is the social aspect of it is taken into account, but also that the governance supports the flows of data, which will support that the demonstration of effectiveness. So they have to be competent. Competence is an important part of trustworthiness. But the other part of trustworthiness here is what I think is going to be particularly important for the law to actually support and to be able to deliver on. And that relates to integrity and benevolence. So do people perceive the digital tech to actually work for them and for those that they care about? Do they get something out of it? Does the app and the use of the data reflect their values? Does it protect their interests? Now, we know that the use of these apps doesn't take place in a vacuum. We know that there's a lot of concern in relation to data more generally these days, concerns often associated with mission creep and secondary uses of data, data being used for purposes beyond the original purpose for which it was disclosed. And there are, in this context, a series of considerations in relation to the digital tech which relate to that question of mission creep and concerns in relation to secondary use. So the first thing I'll just call out relates to the location of the data. Where is it being kept? Is it only on the device which is in the hands of the consumer? So is it being held in a way that actually physically prevents any secondary use? Or is it being shared with a third party, a private company, a government? If it's being shared, if the possibility for secondary use exists, then what are those permitted secondary uses? What are allowed and what's being prescribed? And it's important here to recognise that a perceived misuse may well go beyond questions of law. People often perceive a misuse of data to be a use of data for purposes other than that for which it was provided, regardless of whether or not it's lawful or not. So the question of whether or not people are going to accept a use is not necessarily answered by questions of whether or not a use is lawful. So what are the permitted uses? Are there any permitted uses beyond that primary and principal use of contact tracing pandemic response? What are the rules that proscribe any additional uses? And how effectively can those rules be enforced? So there was, in relation to Australia's COVID Safe app data, an initial concern, at least discussed through the media, about the data being held by Amazon Web Servers, AWS, and the questions to whether or not US law would permit US intelligence agencies to access that data because of the relationship between Amazon and the United States of America. So could even Australian law effectively control uses of data in that context? That was one of the questions that was being asked. So what are the legal controls that will proscribe uses beyond the primary use, will prescribe any secondary uses, and how effectively can those laws actually be prosecuted? In relation to that effectiveness of enforcement, another issue that arose in Australia is when we tended to move from the use of the COVID Safe app, which the use of it tended to fall away, principally because of those issues of competence and whether or not it was actually seen to work and be effective. There was a move towards the use of digital tech to support QR codes and location tracing, contact tracing in that way. And employers and companies and organizations were required to maintain some details, are still required to maintain details of people who frequent their establishments, collect names, contact numbers, those kinds of things. Well, initially that was done through the companies themselves collecting that information, first of all paper-based and then digital, using these QR codes, but the QR code systems were being provided by private companies. They were collecting the data through web surveys, web survey tools. And although they weren't supposed to collect any more than first name, telephone number, location, date and time of entry, although they weren't supposed to use this information for anything other than the public health response, in fact, routinely routinely, I and many others experienced web surveys prompting for additional information, including requests for permission to use data for marketing purposes. When you roll out this kind of major change across the whole of society, the ability to ramp up enforcement in a way that ensures that the rules can be effectively policed becomes a massive question and challenge. In part because of that, I think we moved away from companies relying upon their own capture and web surveys to a government provided app. In Victoria, we have the Service Victoria app now, which all companies are required to use rather than their own digital platforms. But that comes with additional questions, or at least alternative questions in relation to secondary uses, and there have been issues in relation to secondary uses by the police, and there's been a somewhat uneven response across the states to requests by the police to get access to that location data. Gradually, the states and territories have tended to move towards prohibiting that, or at least significantly restricting it. So, for example, in Victoria now, the legislation proposes that police access would only be permitted if there was an imminent threat to life, health, safety, or welfare, and there was a court order. So, in short, and just to summarise, public confidence can be undermined if the uses are not seen to be uses which are in the individuals and community interests, and governance in this space needs to be able to support trustworthiness and protect against misuse. And it's really important to recognise that misuse is often perceived by public to be any use of data beyond that for which it was originally provided. Thank you.
Thanks for that, Mark. I do hope that everyone can now hear me. We've been having some, right, it's a little bit ironic, but we are having some connectivity issues in WHO. So look, thanks for those fantastic comments. I think that you raised, it was really helpful to unpack the difference between trust and trustworthiness and some of the elements involved in that, and particularly the perceived risk concerning mission creep. And I think that we've all come across situations in our personal lives where we've been asked to provide information for the purposes of contact tracing or such like, and then later down the track found that we've received marketing material and so on. And I think that we've seen it play out as well. You mentioned law enforcement agencies seeking access to personal information extracted from our contact tracing efforts. And I think, as you were alluding to, the risk there is that it may undermine the public health effectiveness of those technologies, because people may be less willing to share the information and to be honest with contact traces. And of course, during a pandemic, our principal interest really is in getting getting accurate information from our cases and our potential contacts, and those sort of secondary or potential secondary uses of the law of the data. Have a lesser significance during a pandemic scenario. So, look, with that, and apologies again for the connectivity issues. What I might do before we move to the next speaker, I just quickly turn to my colleague Alyssa, who will just briefly share a link for Padlet again. We had some great comments made during the last session, so I'd encourage all of you to get on that and to utilize it as well. Over to you, Alyssa.
Thanks, Ben, and thanks, Mark, for that presentation. So I'm just putting in the Padlet link for this session. For the benefit of those who just joined us for this session, Padlet is what we're using to capture all of your valuable feedback and comments and reflections based on some of the questions that we posed to the panelists as they prepared for this forum. So if you click on this link and type in the password, it's health law all in lowercase. I'll just type that into the chat as well. You'll be able to access Padlet. And I'll just quickly again share my screen. This is what you should see once you are in there. And to add a comment to any of these questions, you can click on the plus button. In the subject, you can type in your name and affiliation. So for example, Alyssa Leo Wipro here, and then your comment would be included here. If you do want to attach any documents or links to your answer, you can feel free to do so here. This is what you use to type in the link. You can upload document here. And once it's done, just click on publish and I will be able to see it and approve it and have it on the board. So I'll be around on chat if anyone has any questions. Feel free to reach out to me. Thanks. Back to you, Ben.
Thanks, Alyssa. Now we'll be turning to our next panelist, Dr. Pira Angelo Wiko. Pira.
Thank you. Just sharing my screen. Can everyone view my screen? Okay, so again, good morning, good afternoon, and good evening. It's a pleasure to participate in this forum. I am Dr. Pura Angela Ko, Country Manager of Think Well in the Philippines, and today I'm tasked to share insights and lessons we've garnered on the legal and regulatory environment for digital health as we were providing support to the Philippine DOH for the COVID-19 telemedicine sandbox. So as a short background in terms of the country, there has been a growing number of small-scale implementation of digital health solutions in the public and private sector over the last decade. So these have provided insights into how digital health can be used to improve health outcomes in a low middle income country. However, uncertain government policies have constrained its development. So over the years, the country has developed an e-health strategy, a data privacy law, and started to ensure linkages with the National Health Insurance Agency. But these developments have been slow and a lot of gaps remain. So in terms of demand side, internet literacy had been improving in the country, although much needed to be addressed in terms of connectivity. Overall, the lack of effective political prioritization, as manifested by inadequate ICT infrastructure and poor use of policy levers, have led to the slow adoption of digital health solutions. So the COVID-19 pandemic further emphasized the need for effective digital health solutions. Fear of catching the virus and the government-instituted lockdowns made access to healthcare increasingly difficult. Healthcare providers needed solutions to access information and provide healthcare remotely. So the government, mainly through the DOH, responded to these challenges through multiple mechanisms. So it centrally developed digital solutions, including offering a hotline for COVID-19 concerns, developing a chatbot to help in disseminating information, as well as developing websites and apps for submission of COVID-related data. It also offered guidance for LGUs, providers, and other stakeholders in areas such as the conduct of telemedicine and in data privacy. But to fully scale the use of digital health solutions, though, the government also needed to engage with external stakeholders, including the private sector. They were able to do this through the adoption of the contact tracing Stay Safe app and through the establishment of the telemedicine sandbox. So again, we were able to take part in the sandbox as its process documenters. So the telemedicine sandbox was jointly administered by the DOH and the National Privacy Commission by enabling a no-cost partnership arrangement with telemedicine providers to offer a free consultation during the pandemic. So and the engagement was treated like a regulatory sandbox where the DOH was able to closely monitor and learn from the implementation to strengthen its regulation. So for telemedicine providers to be engaged, they had to secure certification from NPC and DOH that they are compliant with current privacy and quality standards. So engaged telemedicine partners were advertised to the public through official channels, and in return, the providers were required to submit their utilization data to DOH for the duration of the engagement. So in total, around 5 providers joined this initiative during the pandemic. So its implementation so far illustrates the potential strengths and limitations of how digital health solutions can expand the accessibility of health service delivery. Through the sandbox, the government was able to provide a significant amount of consultation to those affected by the pandemic. These were mostly provided through telephony, since this is the medium that's most accessible to the general population, even if there are limitations in the information that's being garnered from it. For the DOH, the sandbox was a driver for them to create regulatory processes and mechanisms, such as the certification process for the different telemedicine providers. From this process, safety and privacy gaps of these providers have been assessed and addressed. So there were a number of legal and regulatory concerns that have arisen as well because of the scale offered by these digital health solutions. So for example, data protection and legal concerns from offshore data storage was also a repeated concern, as what the previous speaker was also mentioning, especially with most data being stored on the cloud. So enforcement capacity of the government is also an issue, with some providers complaining of slow turnaround time and lack of follow-through of the government in terms of next steps. Sufficient incentives is also a concern, as shown by the waning interest of providers to join this initiative. Beyond the sandbox, there's also a question in terms of the quality of the unregulated digital health services that's being accessed by the general population. Ultimately, the inadequate capacity of the government to regulate digital health solutions will serve as a constant barrier to equitable access to digital health solutions if appropriate reforms are not made. So, a summary, the country was able to demonstrate the value of digital health during times of emergency and even beyond. Because of the pandemic, there's been an increased movement in terms of legitimizing the technology and the industry. However, significant gaps remain, and this exercise has also generated useful insights into the continuing and often unforeseen risk of digital health. So to further improve access to digital health service, the government, with DOH's lead, needs to further enable a conducive multi-agency regulatory environment leading to responsive policy making. So this in turn will lead to appropriate incentives and disincentives towards quality and equitable access to digital health service. So lastly, the government still needs to continue and getting further insights into the broader health policy environment of digital health. So there's a need to further generate knowledge on this subject that would lead to the development of more responsive policies that better fit the context unique to each country and the technology being regulated. So thank you.
Thank you, Dr. Wiko, for that very efficient presentation where you covered a great deal of content in a very short space of time. I think it's a fascinating approach that was taken in the Philippines. Of course, regulatory sandboxing is not a new approach. It's seen quite often in other regulatory environments, particularly financial regulation. I don't know if it's been widely applied in our region in the health space, but I think it's interesting to reflect upon the work that occurred in the Philippines and some of the outcomes that were achieved, and what sort of challenges that you face were, and potentially what some of the benefits in that approach were as well. And certainly, as someone who's been in the Philippines, I've noticed as well a proliferation of telemedicine service providers recently. And so it's interesting to consider how those services might be regulated, and as you mentioned, how the government might use legal and regulatory frameworks to ensure appropriate quality and to ensure cost effectiveness as well. So maybe we might move on to the next panelist. Next up, we've got Tensi Yao from the Singapore Ministry of Health. So over to you, Tensi.
Thanks very much, Ben. I think I had a deck of slides. If not, it's okay. I can just freestyle.
We'll locate the slides for you and we'll share them as soon as we find them. Thanks.
It's all right. I'll just sorry. Good morning, good afternoon, good evening, everyone. If the slides can't be put up, I'll just base my presentation on the framework that Mark had earlier spoken on, the one about trustworthiness being important and competence, integrity, and benevolence. So I work in the government of Singapore at the Ministry of Health. So the perspective I'll be sharing today will be the government's perspective. And I think, like most countries, we had implemented digital contact tracing solutions and digital quarantine monitoring and things like that. The title of my presentation was actually Big Brother is Legally Watching You. Oh, thanks very much, Elisa. Yeah, so could we go to the first slide? Yeah. So our contact tracing solution is called Trace Together. I don't think it's very different from the one they have in Australia. It uses Bluetooth signals to just see who you've been in close contact with. And subsequently, if you're determined to be a COVID positive case, the government will be able to retrieve that data to do contact tracing to ensure that your loved ones are protected and to ensure that there are no clusters that will break out. I was going to actually break this down using the framework that Professor Mark Taylor spoke about earlier. So I think there is no question that the citizens of Singapore are aware that these technological solutions are viable. So the competence issue is quite settled. These do work, or at least they do work when the numbers of infected in the community are not overwhelming. I think prior to the Delta variant, this Trace Together solution was very effective for Singapore in containing the spread of the infection and to make sure that our numbers were low. So the issue I would say for our government, for Singapore's government, was the one about integrity. And I think Mark said many things that resonated with me, or rather, should I say, he said many things that I wanted to say. So now that he said them, I suppose I can give a practical application of the principles that he spoke about. So the issue of mission creep was actually a very real one, and it did come up in our country. So initially, these technological solutions, these trace together applications and tokens, they were adopted by our citizens voluntarily. I think Mark mentioned that 80% of the people in Ireland just were willing to do it. And it was similar in Singapore. There was quite a high demand for these application devices. But one thing that I would say may have been overlooked was that we didn't think about proper reassurance to members of the public about how the data would be used. So the primary purpose, right, is for contact tracing, is for public health purposes, is to prevent the spread of infection. But there are statutes in Singapore that, pre-existed these devices. And for example, there's the Criminal Procedure Code, which allows the police, right, the state, to require information related to the offense, the commission of an offense, to be handed over to the authorities. And one angle was that the information in the device and in the application, stored locally, by the way, it is stored locally until it is you are found to be COVID positive, in which case the data is transferred to the government servers, not AWS. But because of the provision in the Criminal Procedure Code, people were worried that the government will be using this contact tracing data to investigate other kinds of offenses, right? So that would in turn impinge on the take-up rate for these devices and applications. So because this was such a pressing concern, actually an apology was made in Parliament, and an amendment to the relevant legislation was made to make it very clear that all this data, the trace together data, would only be usable for the purposes of contact tracing or for the purposes of maintaining the contact tracing system's integrity. So it was quite big news in Singapore because politicians seldom apologize. But after this, I think people were more reassured and they could go about with their daily lives with these devices, safe in the knowledge that there would be a law protecting them. I think Mark also mentioned that, we need to know how enforceable these rules that prescribe the use of the data are. So Singapore being a very small country, we are a city-state, and I think we are probably smaller than most Australian cities physically. It is easy to enforce. The problem is, this is one of those laws where you would be enforcing it against because the only people who have access to the data are people who work in the government. We do not use third parties because, you know, I think Mark mentioned earlier that there's a much higher risk, or rather much higher perceived risk of abuse. So the government gets all the data, and if there is any prosecution to be taken out, it would be against a government employee. Thankfully, to date, there has been no such case. I think the benevolence, for want of a better word, is there. Everyone knows that these solutions are only intended for contact tracing. But I have to say that maybe this is, and I'm speaking, you know, personally here. I'm not representing the views of my employer. There is a tendency in Singapore towards law and order. So while amendments were made to make clear to the public that this data will not be used, you know, for investigating most offences, there was a certain list of offences that was carved out, and for these offences, which are like terrorism and kidnapping, the trace together data would be usable for investigations. So I think this was a bit of a halfway house, and we all know that a good compromise leaves nobody happy. But it was decided upon, and that was the position taken. I think on the ground, much of the population greeted the news with a slight sense of derision, because if you are going to be a terrorist, carrying out a terrorist attack, you are hardly going to be carrying one of these devices around you. But I digress. Before I move on to the next slide, I just wanted to point out something interesting about this trace together solution, which is that initially we had thought that most people, because they already have smartphones, right? They have their iPhones, they have their Androids, they would just download the app and just use the device, the app on the device for the purposes of contact tracing. But as it turned out, there was actually a massive demand for the tokens. We did some analysis, and we came to realize that people actually preferred the tokens because they perceived it to be safer. It was a physically separate device from the phone, and you know, it just seemed harmless and innocuous. So even though from the engineers, both are identical in terms of potential invasion of privacy, many people much preferred the physical token, and maybe this is something we can, or at least this is something that the government will take into account when we are designing future solutions. Yeah, next slide, please. This was another technology that we still use to this day. Trace Together was meant to map person-to-person transient or non-transient interactions, whereas safe entry is something that you do whenever you go to a shopping mall, a restaurant, or a shop. You just check in, and now it's been integrated together with the Trace Together application and the Trace Together token. So the same issues arise, but and the same privacy safeguards are there. You can't use this data to investigate except, you know, only the most serious crimes. The data that is logged is stored locally on your phone and only transmitted to a server once you've been determined to be a COVID positive case. There is no question of any more mission creep because of the legislation, and there's no third parties being used to store the information. Yeah, so since this is largely similar, we can move on to the third slide, which I think is a bit more interesting. So in Singapore, whenever someone is COVID positive, we usually try to isolate that person, or at least, yeah, we try to isolate them. We have a variety of measures. You have a quarantine order, an isolation order, and one of these is the stay-home notice. For people who are under a stay-home notice, which is slightly less serious than a quarantine order, the supervision is not as robust, but we do use a technological solution to that. So if you receive an SMS to say respond, then you have 1 hour to do so. I think this solution, I mean, it appears at first glance to be very invasive, but actually, I think there's quite a nice compromise here. You don't have to turn on your location services at all times. You only have to do it when you are pinged, and the information. I mean, if you you are given a bit of a chance really to rush home within an hour. And if you are out, you've been out and you can't come back within an hour. Singapore's a very small country, by the way. Then you do deserve to have your privacy invaded because you have broken the law and you are a public health risk. So I thought this illustrates nicely how what a good balance between privacy and expediency is. I think it was Mark earlier who also noted that if you don't have trust in your solution because of the lack of trustworthiness, then it will be very difficult to encourage people to take up the digital solution. And for something like contact tracing, activity mapping, network effects are everything. And if you don't have enough people to constitute a viable network, then the solution is worthless. So compromises like these are actually very valuable and very important to encourage people to be part of the solution to help weed out the infectious disease spread. Next slide, please. First, I have to preface that this solution was actually not really used extensively, as you can imagine. It is something that is not going to be very popular. But in a nutshell, it is a tracker, and we found that even with the assurances that it's not equipped with audio or video recording capabilities, it was not something that went down well with the population, or should I say the electorate. But yeah, I think I just put this in to round up all the measures that we do use, the spectrum of measures that we have in Singapore. Next slide, please. Yeah, so I've mentioned this earlier. My conclusion was basically my speech, really, that we do need to find a way to strike a good balance between personal privacy and the needs of public health. Actually, as a tangent, we are witnessing this more and more as the cases in Singapore are increasing. People are frustrated. They're growing frustrated with people who don't use these devices. And actually, on the vaccination front, people are also frustrated with people who refuse to undergo vaccination. That's an analogy. But the basic question is whether the needs of the many should trump the needs of a few. I think as a jurisdiction, Singapore has never really had particularly strong privacy rights. So it was quite easy to introduce these digital technology solutions. But that is not to say that the status quo will be maintained forever. And speaking, that is me speaking as a government man, but speaking as an individual, perhaps it is also time for us to think about how to better protect privacy, given how these solutions will become all pervasive, and given how data breaches and security hacks and all things like that will become more and more commonplace. So actually, that is all I have. I must say, I did want to ask Mark a question about the benevolence point. I don't think I caught him unpacking the third limb of the trustworthiness framework. So I've talked about competence and integrity, but if we are going to talk about the benevolence of the Singapore government, I think I would have to leave that at the Q&A. Okay, thanks very much, everyone.
Thanks for that, Tensi. Look, another fantastic presentation, and yeah, let's pencil that in as the first question to our Q&A at the end of the panelists' remarks. So I'll hand that one over to Mark when we enter into the open discussion. But yeah, a fascinating presentation. I think that in a lot of ways, Singapore has been a little bit of a leader in our region in this space, and certainly the Trace Together technology we know generated quite a bit of interest in our region, and there were some applications that were in other countries that leveraged that particular form of technology. So it's interesting, I think, to reflect upon how its effectiveness in Singapore, and perhaps compare and contrast that with some other jurisdictions as well. And I think that you mentioned that in the title of your slide, it was I think it was Big Brother is watching you legally. And I thought that was sort of quite a cheeky title. I think the question I would ask is whether we're now moving from an age of Big Brother to an age of Big Brothers, where I think much of the focus has been on the privacy risks associated with the government collecting and using data. But we've also seen during the COVID-19 pandemic the proliferation of private applications, as well as obviously the government's dependency on private platforms as well to implement its own applications, and then how those risks are perceived by individuals and communities. So thanks again for your rich presentation. We'll now pass to our next panelist, who is Dr. Viengsavan Kitipong from the Lao People's Democratic Republic. And I believe that we have some slides to share. Over to you, Dr. Kitipong.
Yes. Good morning, good afternoon, good evening. My name is Dr. Viengsavan Kitipong, Chief of Surveillance Division, DCDC Lao PDR. Sorry, my video have problem. I am very pleased to, on behalf of Lao team, to share with you about recall framework and its role in digital technology in COVID-19 response in Lao PDR. Next slide, please. Regulatory framework for the use of digital technology in health is an area where due attention has not been given so far, and the need to strengthen this key area was highlighted during the preparedness and response to COVID-19. This need was most felt when Lao PDR start developing and using different digital technology. Next slide, please. As in most other countries, Lao PDR to embark on using many digital health technology in the response of COVID-19, a system which promotes the use of taking wristband for those arriving from abroad and quarantine was introduced by a private company. A mobile app to track the movement of commercial tax entering the country was developed and rolled out to ensure adherence to national guidelines. Many different information systems were rapidly developed to support the capture and management of data of those tests for COVID-19, confirmed case, hospitalized case, to track capacity data of quarantine center and isolation facility, and to keep count of the number entering the country through the various point of entry. Similarly, systems were also rapidly developed to capture data on those vaccinated for COVID-19 and for the issuance of vaccination cards with verifiable QR codes. Due to the widespread use of the platforms such as WhatsApp, vital and confidential data is transferred through such platforms, systems were also implemented for social media listening for enhanced surveillance as well as for improved communication strategy. Next slide, please. Although many these mentioned systems were successfully rolled out rapidly, some of them require strengthened regulatory framework for long-term sustainability, compliance and enforcement, and for better preparedness for future health emergency. Area where strengthened regulatory framework would be particularly beneficial in Lao PDR includes for improved compliance for national guidelines and to overcome challenge in enforcement, to be able to engage better with private sector while not compromising on data confidentiality, to facilitate seamless interoperability between systems from different sectors such as immigration data at point of entry without having duplicate efforts. For improved clarity in role and responsibility of other ministries, such as the Ministry of Technology and Communication is supporting the development use digital technology to ensure purpose limitation or entirely disclosing the use of data for purpose for which is correct and not use it for other purpose. Next slide, please. Finally, just to boldly share some of the lessons learned by Lao PDR, the use of digital technology are pivotal in responding not only COVID-19, but it also going to be pivotal for dealing with further health emergency. Therefore, national public health law need to be amended to facilitate the appropriate use of digital health technology while ensuring necessary measures are in place to protect data confidentiality and protect that protection and that they are not used for deny any service to the people. It should also be clear on how private sector could be safely engaged to rapidly roll out digital technology for the greater good of the people we serve. ขอบใจหลายๆ Thank you very much for your attention.
Thank you, Dr. Vien Savan, and thank you for your reflections on some of the practices in Laos, some of the challenges that you face, and your suggestion of what some of the priorities might be for the future. There were a number of points that you made that I found quite interesting, and I think we're starting to see some common themes emerge. And I think it's interesting to note that both Singapore and Laos, two quite different jurisdictions, raise the challenge of enforcement. I think it's one thing to have sort of legal and regulatory frameworks on the books. It's another thing to have the capacity to enforce those, or to enforce those standards. Particularly where you have a new and emerging technology that the government may not yet fully understand. And I think it was also quite interesting you mentioned the need potentially to review your public health law in light of how digital technology has been used for surveillance purposes during COVID-19. I think that was something that was mentioned by Genevieve and some of the panelists in her session, that many of the public health laws in our region date back to a time where information was collected and shared very differently to how it is now. We didn't contemplate the potential applications of technology in this space. So thanks again for your presentation. We'll move on to the final panelist now, Kyle DeYoung, who's a consultant with the Health Law Networks team here at Wipro. Over to you, Kyle.
Hi, everyone. Thanks, Ben. For my presentation, I'll be speaking a bit about the development of legal frameworks. And just let me share my slides here. So as we've heard from a number of presentations thus far, legal frameworks are incredibly important for the development of digital technologies and specifically digital contact tracing and quarantine tools that have been deployed during the COVID-19 pandemic. The WHO Office for the Western Pacific published a document through the Health Law and Ethics team in June of 2021 titled "The Considerations for Strengthening Legal Frameworks for Digital Contact Tracing and Quarantine Tools for COVID-19." And this document outlines the steps and the important considerations that need to be included when legal frameworks are created to respond to the tools that were rapidly rolled out for contact tracing and quarantine for COVID-19. There's been a lot of discussion so far, so I'm going to maybe jump through some of the earlier bits of my presentation just to get to some of the more important development.
Sorry, Carl, just to jump in, your slides are appearing in the presenter view, so I don't know if you want to maybe change that to the full screen.
Yep. Sorry about that, just 1 second, I can't get my screen share to work again.
Hi, Kyle. If it's easier, we can share your slides.
Sure. Just 1 second.
Perhaps you can share your slides with us in the chat, Carl, and we'll put them on the screen. But feel free to continue with the presentation in the meantime, and we'll look to share them as soon as we.
Correct. Yeah, no worries. Just 1 second. I'll just keep going. For some reason, it won't drop my slides in. So I'll just speak from my notes. It's okay. So as we heard earlier, there are a number of legal and ethical dimensions to the development of the digital contact tracing and quarantine (DCTQ) tools. As we've discussed, the amount of information that's collected and how it's being collected is incredibly sensitive to a number of people. And the amount of data that's been collected is immense at times. And the sensitivity and the trust that is at play, as Ben and discussed early on, is incredibly important for the actual effectiveness of the tools. If the users don't feel that their data and their information is protected and is being utilized for a valid reason and is secure, then people will not use the apps. And the report in particular focuses on Bluetooth and GPS style apps, similar to Trace Together that we've just heard about. Additional legal and ethical dimensions from the considerations for the tools are things like the risk of commercialization within public health infrastructure, meaning if private companies are participating in the development of these DCTQ tools, then there's a risk that data or information can be transferred to private companies, or vice versa, where private companies have access to users' data and can use that for commercial or other types of purposes. As discussed earlier, the application of the DCTQ tools has a direct impact on individuals' autonomy, and it has the potential to exacerbate inequities. If, for instance, having a Trace Together or another type of DCTQ tool on your phone is a requirement for entry, and you don't have access to a phone, or you don't have access to a token, that can place many barriers into individuals' day-to-day lives. There are a number of reasons that legal frameworks are important for the development of DCTQ tools. It's really important to establish a lawful basis for the use of the tools and to govern the use of the tools and their data, and also ultimately to cover the dismantling of the use of the tools and their data at the end of the need or the pandemic or whatever the underlying public health rationale is for their development. Legal frameworks are important to provide safeguards and to ensure the privacy and secure retention and encryption of data. And overall, having strong legal frameworks in place, as mentioned earlier, builds public trust and ultimately encourages and supports the uptake by members of the public. Primary legislation, so statutes, law, is the most effective means to achieve these purposes. And that's because, and I'm sure we're all aware of this, but lots of apps and lots of tools come with terms of use or privacy policies that users, might not understand in its legalese. I'm sure we've all scrolled through websites or privacy policies for apps that we've never read and just scroll to the bottom. So having a strong primary legislation in place for the DCTQ tools is incredibly important to allow individuals to actually understand what they're signing off on. And in the region, overall legal frameworks for both personal use information generally and for e-health data and privacy exist, but they're not universal, and their use is growing. So the lack of those types of legal frameworks in some jurisdictions means that specific legal frameworks for things like DCTQ tools is incredibly important. And just finally, the document, as I mentioned earlier, has a checklist that outlines a number of considerations for the development of legal frameworks for these tools. And these considerations kind of run the gamut through a number of different things. There has to be a clear understanding that users are consenting and voluntarily using the tools. The amount of data collected should be minimal, the minimum amount required for the actual goal of the tool. There should be clear outline of how data will be kept secure, how it will be encrypted, and how it will be used. There should be time limits on how long data will be held and what will happen to the data at the end of the period of use of the tool. And there should be clear oversight and governance. So who within government is administering the tool and who is overseeing the tool's use and evaluating its use. And finally, there should be a human rights and equity lens on any work that's done with respect to DCTQ tools, because as mentioned earlier, these tools can place barriers on entry for lots of different sectors within society, and any barriers or any impact on marginalized groups should be at the forefront of any consideration. Thank you.
Thanks for that, Kyle, and apologies for causing, I think, some of the issues there with your slides. And it was very late in the evening where you are, so it's a little bit unfair of us to disrupt your flow there. But thank you. I think that you raised a number of really interesting points. Actually, and one thing that you mentioned was that we know from the Global eHealth Survey, I believe conducted in around 2015, that the Western Pacific region has one of the lowest concentrations of general privacy frameworks among all WHO regions. And of course, member states in our region are at very different stages in terms of developing their legal and regulatory environments for digital health. And we certainly shouldn't expect that countries would start from a low base and then develop a robust legal and regulatory environment that encompasses all of the principles and considerations that we're mentioning. But it is certainly important, I think, for member states to consider what their priorities are and potentially what their long-term vision in that space is. I think that there's a number of intermediate steps as well that countries potentially can look to make to build those frameworks over time. So it's something that in our office is something that we're looking to support a number of member states in the region to conduct exercises just like that. So thanks again for that presentation. We're now moving into the open discussion part of the forum. So please get your hands ready. Before we open up to the floor, what I might do is pose Tensi Yao's question to Mark Taylor. And I believe, correct me if I'm wrong, Tensi Yao, but you were keen for Mark just to elaborate on the issue of benevolence and how that factors into trustworthiness and potentially the role of the law in that space as well.
I've put a link into the chat, Bill, because there's a lot of literature on trust and trustworthiness, but one of the pieces I quite like came out in '95 in Academy of Management Review, Mayer, Davis and Schurman, an integrative model of organizational trust. And I've put the link to that article, and they use this framework. They talk about ability rather than competence, but they talk about ability, integrity and benevolence. And when they talk about integrity, they're talking about the trustor's perception that the trustee adheres to a set of principles. Do you adhere to a set of principles that the trustor finds acceptable? So I think this is a kind of a set of values. Do they ascribe to a set of principles, a set of values which are called with those which you yourself hold and which you consider to be acceptable? Benevolence, they describe as the extent to which the trustee is believed to want to do good to the trustor, not from an egocentric profit motive, but do they actually want to do good for the person that's investing trust in them? And so they're talking about benevolence there, which of course is might be associated as an attitude of a person, a benevolent person. It's a kind of a moral virtue. We might talk about systems, particularly, we might talk about systems, information systems, digital technology, not necessarily in terms of benevolence, if we're not talking about the individual's motives behind the use of them, but we're talking about the operation of the systems themselves. We might instead talk about beneficence rather than benevolence. Do they actually work to the good of those who are using them? And so I think they're slightly different questions, or slightly different issues, those of integrity and those of benevolence. And benevolence or beneficence is really about whether or not it's actually going to work to the good of the people who are using these technologies. And if we want people to willingly accept whatever risks they perceive to be associated with these technologies, then kind of put it simply, what do they see as in it for them? How does the use of these technologies work in their interests, in their favour? How does it do them and their loved ones good? Does that help at all?
Thanks very much, Mark. I suppose coming from quite an authoritarian country, I'm just wondering what would be a good way for the government to demonstrate benevolence. I mean, assuming that they've had a history of not being benevolent or beneficent. So what would be a quick and easy way to convince people for this particular application, for this particular context, you can trust us, this is good for you? But if this is impossible to answer, it's fine.
First of all, I don't think you say you can trust us, because it's saying to somebody that you know it's okay, you can trust me, isn't necessarily the very best way to demonstrate that you're worthy of that trust. And I think I think you mentioned this within your own presentation, which I thought was great. Really clear articulation of how this might work in practice. There is this. There's a need to demonstrate the value proposition. Just what good is this going to do, and why is this good for you? But alongside that, there's a need to demonstrate how the potential misuses are going to be guarded against. And I think often, particularly by people who are well-meaning and perhaps are benevolent or operate with a principle of beneficence, there is this rush to do good. And in the rush to do good, they don't necessarily give adequate attention to the misuses which might be made of data, because that's not their intent. They don't want to do bad or harm. And because they don't want to do it, they don't consider preventing it. They don't necessarily give sufficient attention to it, it's my view, and it's to some extent my experience as well. So I think that what I'd be encouraging those who are benevolent to do is to consider what misuse might be made of the data from the perspective of the individuals who you're asking to trust you, and then to put beyond doubt that there can be no such use, or if there is any such use, you know, you've done all that you reasonably can be expected to prevent it. So in Australia, I'm thinking about something that Carl said. In Australia, in relation to the COVID Safe app, when it's used and the control of the data came through a ministerial determination, one of the concerns was with the way in which the law can be changed through ministerial kind of decision without having to go through a parliamentary process. And it wasn't until that the controls were effected through a different kind of instrument, a primary legislation that required parliamentary consideration, that people felt that it's not just that the rules were right, but they were sufficiently kind of assured into a medium and long term as well. So just some initial thoughts. So
thanks very much. Thanks. Yeah, that's useful. The problem is, what if we are not inherently benevolent? Then, but you know, that's fine. Let's move on.
Thanks for those very thoughtful comments. That was a great discussion that I really enjoyed. And I think you touched on something, both of you, that there are very different values that exist in our region, and public health authorities to a large extent are dependent on the general trust in our government, and of course that will have a big influence on trust in the public health response and of the use of digital health technologies generally. And something we haven't really had the opportunity to touch upon in this session yet is exploring how different values with respect to our privacy may necessitate different types of legal frameworks, different types of our legal mechanisms. And people in different parts of our region may be concerned about different forms of misuse, not only in terms of the populations that may be targeted, but in terms of their understanding of the risk, particularly as individuals versus potentially a community-based risk, and how that might play out and what different legal mechanisms we might be able to consider to resolve some of those concerns and to ensure that youth digital health technology, as you mentioned, Mark, is benevolent and can engender trust in the population, because ultimately that's what's going to ensure that it's most effective. So we are running over time, but we do have, is there anyone else who has any comments or wants to raise a hand? I'm sure we have time to allow for one comment or question. I'm not seeing anyone. I was told recently to embrace silence and give people space to raise their hands, but I have to admit I did find it quite challenging. Okay, I'm not seeing anyone, but of course the Padlet will remain live. So if you do have any comments you'd like to make through that forum, please do so. So with that, I'll call this session to a close, and I'll hand back to Jonathan Liebman to wrap up for the day. Thanks very much.
Thanks very much, Ben. Thanks to all the panelists for another great session. So we'll draw first day to a close. I'll just make some really brief remarks. So we covered two quite different areas, public health and health emergency laws in the first session, and then digital technologies in the second. I think there was some interesting common themes. I think we saw in both the importance of legal frameworks. We also saw the complexity of the intersection of different legal frameworks. So in the first session, public health, state of emergency, disaster. In the second, public health, privacy, consumer protection, health services, and across those, the importance of having clarity of roles and responsibility, and the importance of trust and trustworthiness. I think we saw in both that COVID-19 has presented challenges to the frameworks that we might not have anticipated before a pandemic of this nature. We've all been learning really important lessons in real time, and doing our best to adapt, to review, revise, improve laws. And I think we saw that countries are really dealing with really common challenges, but also some different challenges, and taking different approaches that are appropriate for local circumstances. So I just very briefly will just remind you what's ahead for tomorrow. We'll start again at 9 a.m. Manila time. The first session will be on engaging the whole of the health system in the COVID response to meet surging demand. Then we'll have a short break, and then we'll have a session that looks at how we build and mobilise legal capacity, both for the COVID-19 response and for legal preparedness beyond COVID-19. And then we'll have a closing session where we'll wrap up, tie together some of the themes of the 2 days, look ahead, and then we'll have a keynote address in the closing from WHO Wipro. So thanks very much, everyone, for joining us for a fantastic first day. Looking forward to seeing you back tomorrow, as I said, at 9 a.m. Manila time. Thanks, everyone.
Thank you. Bye-bye.